Chair would now recognize Representative Cook to lay out and explain House Bill 3330.
Mr. Chairman, like Speaker Moody, I just have a simple little bill with very few witnesses, if any. I don't know if anyone's here to testify or not, but appreciate the opportunity to lay out House Bill 3330. In all seriousness, do appreciate the committee's attention. This is a very important bill, and I do not take the filing of House Bill 3330 lightly. I know that this legislature, prior to my being a member of this body, in 2013 passed the Michael Morton Act, and I want to make it very clear that it's not my intent, it's not the intent of this legislation to undo or to attack the Michael Morton Act. I know that not everyone agrees with that, but that's my interpretation and how I feel about House Bill 3330. I think really what this bill does is it really goes to the crux of what happened in the Heath case, and really what I think has happened here as the term the state, quote unquote the state, that term has been blurred with the roles when you talk about prosecutor or law enforcement agencies. They've been lumped in together and are being considered in the same meaning, and I believe that that's one of the primary intentions of House Bill 3330 is to uncouple or decouple those two from one another, in my opinion. As a result of this ambiguity between the definition of the state, the Texas Court of Criminal Appeals in June of 2024, just last summer, held in State v. Heath that a trial court may suppress relevant, incriminating, and inculpatory evidence of a defendant's guilt for failing to disclose it upon request, even when a prosecutor had no knowledge that the evidence existed at the time of the initial request. And I want to just reemphasize that this case stands for that a situation where a prosecutor had no knowledge of the inculpatory evidence of a defendant's guilt, even though there's no knowledge if there's a failure to disclose, according to Heath, there would be suppression would be appropriate. This ruling applies even when the prosecutor acted in good faith and the defendant suffered no prejudice from the non-disclosure, according to the Heath case. Unfortunately, some defense attorneys are now taking advantage of this technicality by not specifically requesting the evidence that they know a law enforcement agency has failed to turn over to the prosecutor. Then at trial, the defense can invoke Heath to have it excluded. And so, just stated another way, is lying behind the log. We've all heard that term, and again, I'm not a criminal defense attorney, but that's what I understand is happening in practice following this State versus Heath ruling. And so this, again, House Bill 3330, that's the intent of this bill, is to address that situation where defense attorneys are aware and that the law enforcement agency has the evidence, even though there's no knowledge by the prosecution, and they wait until the time of trial to invoke it, and then, of course, move to have that evidence excluded, which obviously could and would result in dismissals, most likely, following this Heath ruling. In my opinion, this gamesmanship undermines the integrity of the trial process and our core principles of justice. And I don't think it's a coincidence that the defense bar is in large part against House Bill 3330 for that reason. They like this opportunity to wait and spring it on after trial has commenced. House Bill 3330 seeks to rectify the unintended consequences of the Heath decision, which permits the suppression of inculpatory evidence without a showing of bad faith by the state or any harm to the defense. This bill does not apply to, number one, exculpatory, impeaching, or mitigating evidence benefiting a defendant. Number two, nor does this bill prevent a court from suppressing evidence in case of bad faith by the state, nor number 3, this bill does not provide for incurable prejudice to the defense. House Bill 3330 clarifies the definition of the state for discovery purposes, distinguishing the responsibilities of prosecutors from those of law enforcement agencies. Again, that's the primary change in this bill, is decoupling the state with making a distinction between law enforcement agencies and the prosecutors. We all know that they have separate roles and they have separate responsibilities. House Bill 3330 also established new procedures for requesting discovery. It empowers courts to limit overly broad discovery requests and codifies pre-Heath legal standards governing the suppression of evidence. I want to thank the 35 elected county attorneys, district attorneys, and criminal district attorneys who have joined with Senator Huffman and myself by supporting this legislation and urging the necessity of this legislation being passed. And I would be glad to answer any questions, Mr. Chairman, when appropriate. As stated earlier, there are many witnesses here, and I would request, unlike Representative Curry earlier stating that I would defer questions, but I do think it would be more helpful. There are people, obviously, that are much more experienced and qualified to answer these questions and give you, I think, more specific situations. And I think it would make more sense for me to answer questions after those witnesses have testified, but I'll make myself available now or afterwards at the pleasure of the chairman.
Member, any questions? Representative Moody?
Just real quick. Thank you, Chairman Cook. I know you mentioned your layout, prior work, legislature going back to probably 2013,
Yes,
Michael
sir.
Morton Act. And I know you said it is not your intention to undo the gains of the Michael Morton Act. And so I appreciate that, and I take you at your word. What I do want to do, if it's okay with you, and I've gotten to know Mr. Morton over the years that we worked on stuff. Sometimes we agree on stuff, sometimes we don't. But he couldn't be here today. But he did ask me to give a letter to the committee members, and I think that he's going to send it through the online portal as well, so it's part of the record. I don't want to belabor the point by reading the entire letter. I'll give it to everybody that's here so they can have it, so they know what his position is. He cites two specific sections that he has concerns with, being that definition related to the state, and also he states, and I'll just state it in part, it separates the burden of discovery from being on the state to solely on the attorney representing the state, which could have the effect of reducing the amount of evidence shared between law enforcement and the prosecutor. Number 2, it allows the state, through individual prosecutors, to be the gatekeeper of the evidence and decide what is reasonably necessary to the defense. He also says, he goes on to say, while I will leave the more technical arguments to the attorneys who practice in the area, if these 2 provisions are enacted, they would unwind the protections passed in 2013. And for those of you who weren't here or unfamiliar with Mr. Morton's story, he shared this very brief description. For those of you not familiar with my case, key evidence was withheld from my lawyers. To use the language of the bill, prosecutors determined that key evidence was not reasonably necessary to disclose to the defense. Almost 25 years later, I was exonerated, and the man who murdered my wife was identified when the key evidence was finally disclosed. So I know you stated that you're not trying to turn the clock back on these things, and so I think it's important for his voice to be a part of this conversation as someone who spent 25 years incarcerated for a crime that he didn't commit. And we made some very aggressive changes in this arena to make sure that doesn't happen to anybody else. In fact, the prosecutors in this case in particular, were held to account for what they did. We've changed the law also to address that after that case. And so I'll circulate these to the members so that they have it. And I certainly appreciate all the work that you do on these cases and the attention you pay to wrongful incarceration and making sure that if we're setting up the rules, we set them up in a fair way. So
I appreciate that, and I agree with what you said about Mr. Morton with regard to his experiences as well. And I would ask if maybe we could keep a copy of that letter up here so that when people are testifying, if they want to refer to it as well, if that's okay.
Sure thing.
Otherwise, I would
Any other
request
questions?
an opportunity to close when appropriate.
That's, certainly will. So the chair would call Jenny Andrews. Ms. Andrews, I'm showing you as Jenny Andrews testifying on behalf of Texas Catholic Conference of Bishops against House Bill 3330, correct?
Yes, sir.
Okay.
Good evening. As you said, my name is Jenny Andrews, and I'm testifying today on behalf of the Texas Catholic Conference of Bishops in opposition to HB 3330, which we believe rolls back key provisions of the Michael Morton Act. This act was passed unanimously through both chambers in 2013 as a result of a grave miscarriage of justice in the case of Michael Morton, who was wrongfully convicted and imprisoned for almost 25 years. The Texas bishops support criminal justice reform that provides for compassionate treatment of prisoners, responds to the needs of the victims of crime, and encourages rehabilitation and forgiveness for those reentering society. The strength of our criminal justice system depends on its accuracy, its ability to convict the guilty and to clear the innocent. But we know that wrongful convictions happen. Identifying and understanding the causes of wrongful convictions is critical to maintaining the integrity of our justice system, and every effort must be made to ensure wrongful convictions do not occur. Since 1989, in the United States, 3,659 innocent people have been exonerated after they have spent years in captivity. Thousands more are awaiting exoneration but lack proper representation to achieve justice. It is estimated that 2 to 5% of people in prison are actually innocent. And of those that have been exonerated since 1989, half of the exonerations were cases where the prosecutors had exonerating evidence in their possession at the time of the trial. The gravity of such a miscarriage of justice cannot be overstated. Condemning the innocent makes a mockery of justice. It robs men and women of their dignity, their relationships, time, opportunity, and their personal freedom. Wrongful convictions also endanger the public because locking up an innocent person means that the real culprit walks free. The TCCB's concerns are related to the limitations of the defendant's request for discovery if the court finds that it was unduly broad or burdensome or implicates the security and privacy interests of a victim or witness.
Okay,
And-
let me see if we've got any questions
Oh.
here. Any questions, members? Okay. Ms. Andrews, thank you for being here.
Thank you.
We have Alan Place, who once again, Mr. Place, you registered Alan Place on behalf of Texas Criminal Defense Lawyers Association against the bill.
Thank you, Mr. Chairman. I think you're going to hear a lot of different lawyers today on both sides of this issue. And so in terms of, first, I thought I would try to detail every single passage of the bill. I don't think I'm going to do that. I think what I'd rather do is just point out to the committee real quickly. If you look at A1 of the bill, by changing material to any matter involved in to relevant to any fact or consequence in determining the action, that changes 50 years of case law right off the bat. Okay, that was the law before the Morton Act. Okay, and by adding A2, the only reason to put A2 in the bill is it sets up a process where the state can withhold evidence. That's the only reason for Section A2, okay? But let me just say, every now and then, this body makes a policy statement. And as Chairman, Speaker Moody said in 2013, this body made a real simple statement. And what it was is that if it's a criminal case in Texas, all the way from unlawful carrying a weapon all the way up to the top, if they bring one against you, the policy of this body that passed out unanimously is that the state is going to present the evidence and provide the evidence against you prior to trial, period. That's all it does. And there's nothing, in my opinion, you're going to hear today that's going to change the reason to change that policy statement at all. I'll be glad to take any questions that y'all may have.
Any questions for Mr. Place?
Very briefly.
Yes, Mr. Little?
Mr. Place, thank you for coming to testify today. I've never tried a criminal jury trial. The closest thing I experienced to that was trying the impeachment. And 2 months before the trial in that case, we received 400,000 pages of documents to assess in 60 days. There were documents that were produced on the first day of trial. The documents were still being produced. I can only imagine how terrifying that is, trying to represent someone whose freedom is on the line and documents are being produced at the last minute that you have to assess and then synthesize for someone else's treatment in a trial, right, for a jury's consideration. It has to be quite terrifying. And I think one of the challenges for this committee is, well, do we need to make any changes to the current state of the law? I see in A2 there's a modification that allows the court to limit a defendant's request for discovery if the request is unduly broad or burdensome. I just can't imagine anything more burdensome than having to fight for your freedom based on documents that are coming in at the last second. I mean, how many cases have you been involved in or your membership been involved in where cases are dismissed for the withholding of evidence under the Michael Morton Act? Lots?
I think a dismissal based on the Morton Act, in my opinion, the dismissal on the Heath case was made by a very conservative judge that I've known forever, okay?
Uh-huh.
And basically, what he did is on the fourth jury setting, there were 3 jury settings before the state announced ready. On the fourth one, within a week, they went in there and they found a 911 tape that they basically had all along. The defendant made a motion that it's too late, and the judge agreed. I think judges have independent authority over their dockets long before this case came along, kind of thing. This is not new. But in terms of, I mean, if somebody says today that they filed a Morton motion, it's to get the information, okay? And it is a terrifying thing. I'll tell you up front, I happen to be practicing in an area for 46 years. It's been an open file policy, okay? I've never faced that issue. I mean, when I got out of law school, the DA, here it is. He'd show me. If we couldn't make a deal, we'd try the case. It's not that hard, okay? But since I have been representing this association since 1999, I can tell you there's counties in this state that would not hand over stuff until, even on the death penalty case, until trial. Okay, that's what brought on Morton, among other things. But basically, until there was a soon as practicable requirement, there was no requirement that it had to be done ahead of time. Okay, and so whoever's been the DA in my career back home in Coryell County, there's not a problem, okay? But it is a problem in certain other areas. And that's why the Morton Act came into play with some time limits.
All right, thank you.
Ms. Jones, could you?
Thank you, Mr. Place. To sort of piggyback on what Rep. Little said, what people don't understand is when the state has, let me go back even before that. This country was founded because the government did exactly what they're intended to do in this unwinding of Michael Morton. The government, who has all the resources, literally convicted people because they had all the power, they had the resources to hide evidence, and then it was a little bitty guy going up against the big government with all resources. And so much so that we left England and came over here and did it. So if you believe in the Constitution, then you should believe in the Michael Morton Act. I'm going to say that again. If you believe in the Constitution, you should believe in the Michael Morton Act. And the fact that, I think they said 35 district attorneys and county attorneys have all come together, well, of course, they want the scales to be on their side, even though the Constitution says you, state, you, government, has to prove beyond a reasonable doubt that somebody did what you said they did, how you said they did it, when you said they did, where they said you did it, beyond a reasonable doubt. So I have issues specifically, and I'd like for you to know that Section 1A1 literally makes the state as a gatekeeper The state gets to decide whether they think evidence is relevant. I mean, if that is not letting the fox watch the hen house, I swear on my mama, I don't know what is. Really? There isn't a case where I've seen where the state doesn't want a head start. The state doesn't get a head start. You don't get to do that, and you don't get to decide what's relevant. And here's what's interesting. For example, with the 911 tape, I can listen to it. Sometimes 911 tapes last for a long time. Sometimes I can tell things. I've got to go get an expert to go back first and make sure it's authentic, right? You can't evaluate what a 911 tape says a week before trial. A week before trial, I'm actually making sure that I've investigated the evidence that I received in time for me to investigate it. Now I've got to go back, shift focus to something else that should have been disclosed a way long time ago, and try to go get investigators or forensic experts or people that can listen and weed out stuff. And I literally could find relevant information in a 911 tape that may not be so obvious from what you're hearing, like with the talking. So people think it's not a big deal. And state, I don't understand why the state is whining because something was suppressed. We've always had motions to suppress. If you hide evidence, your evidence is going to be suppressed. You shouldn't get to use it. There's no such thing as reciprocal discovery. This tries to make reciprocal discovery. You know what that means? The Fifth Amendment of the United States Constitution of the United States of America says, I have a right as a person charged with a crime to remain silent. I don't have to give the state anything. I don't have to prove in trial that I didn't do it. Instead, the state has to prove that I did it beyond a reasonable doubt. So that's one thing that bothers me. The second thing that bothers me is that it allows the state to withhold evidence under Section 1A2. The state, so as a state, under this, if I don't like the judge's ruling, the state gets to say, hey, I object. Then we get to have a hearing where and let me be clear, I have literally had cases that get reset for 2, 3, 4 years because the state shows up and they're not ready for whatever reason. And most times the judges will roll with the state. They just do. I mean, I cannot even state the number of times I've had former prosecutors who are now on the defense side say, dude, I was so much smarter on the state side. The state used to uphold all my objections, and now that I'm on the defense side, I mean, the judge is overruling all of my objections. So there tends to be a benefit of the doubt given to the state when it's not always given to the defense. So the fact that the state gets to challenge a judge's ruling and request a hearing, I think is BS.
I agree. I think
that's BS.
It's a binary choice.
I mean, that's a BS. And as a defense lawyer, I don't get to do that.
Yes, sir.
I mean, please help me understand. I also don't like the state.
Can we move on with the witnesses? Because we've got a bunch of witnesses.
Well, I'm gonna I might be able to get it all out with him.
Okay, well, if you can get.
All
it
right, so
all
then
out.
I've got a problem with Section 1A when it defines the state narrowly, right? So it's the state and the investigating agency. First of all, the state relies on the investigating agency to protect me, right? And the state relies on other stuff. If they've got a snitch, right? That's not a state agency. So does that mean that if a snitch is gonna be the main witness against my client, that because it's not a state agency, the state doesn't have to turn that over? That's craziness. I also, this whole Heath thing, was this the Court of Criminal Appeals?
Yes.
The 10th Court of,
No,
let me be
it's
clear.
It's Court of Criminal Appeals.
Is this the Court of Criminal
Yes.
Appeals? Last time I looked, the Court of Criminal Appeals almost always rules against the defense. Almost always. It's like a conservative court. So if the Court of Criminal Appeals suppressed it, then you know it had to really be bad. This flies in the face of the Constitution of these United States of America, that every time I stand before this body, every time I stand up and I put my hand over my heart. So the road to hell is paved with good intentions. The state needs to do a better job. The state needs to know where they're getting information from and when they're getting information, and they should make sure that the law enforcement agency gives them everything. That ain't my problem. It's not a defendant's problem if the police are hiding information from the state. And what this will do, it will actually encourage law enforcement to hide information from the state and say, trust me, I know I had it. Right? So I just think it is a problem, and I'd be curious, what I've just talked about, do you have those same concerns? If no, then tell me how you're
I do.
different.
I think the Heath decision, it ruled on the facts of the Heath case, okay? And basically, the court made a decision to exclude evidence. It went up on appeal. The matter is still pending in Waco, as I understand it. They still intend on trying Mr. Heath. I mean, it's an old case, but they're going to go forward. And so I think what that decision did, it made a ruling on that particular set of facts. That's why I don't think anything's out of whack, as they say back home, kind of thing.
Any other questions, members? Okay, thank you, Mr. Place.
Thank you, Mr. Chairman Smith.
Oh, Mr. Place, they tell me I didn't make the record clear. You're Alan Place, and you're speaking on behalf of the Texas Criminal Defense Lawyers Association, and you spoke against the bill, correct?
That's correct.
Okay, thank you, sir.
Thanks, sir.
Okay, Brent Ligon?
My speaking notes originally said good morning, but that was at 10:30 this morning. My name is Brett Ligon. I'm here to testify on behalf of our Representative Cook's bill. I am one of the district attorneys on that letter, and frankly, I wouldn't care if I was the only one on that letter. I'd be here supporting
Let me
that bill.
let me back you up. Just say I'm sorry. You're Brett Ligon,
Ligon,
and you have you're here on behalf of the Montgomery County District Attorney and self, and you're for the bill, correct?
yes, Your Honor,
thank
or
you.
yes, sir. I proceed?
Sorry to interrupt. Go ahead.
Absolutely. So I am one of the ones on that, on the letter, and of course I have several colleagues here as well. I might be one of the few people that was actually in the room when we were discussing the Michael Morton law. And we all knew what had occurred to Michael Morton was horrible. And no decent prosecutors ever backed off of that. And at the time, we knew that Michael Morton law was not a perfect law. We knew it was something to get out there, and our agency kept saying, it's Via Muerta. It's got to be paid. We'll fix it later on. Now, what Heath says all along, so Heath is a Texas Court of Criminal Appeals case. Justice Newell says several things, and one of which is 3914, which is now referred to as the Michael Morton Act, never set out a remedy for a violation of the Michael Morton Act. There wasn't one, number one. Number two, Justice Newell continues to say, hey, legislature, I want to defer to you, whether it comes to time, whether it comes to remedies. Newell, the justice who decides Heath, says 3914 doesn't have a remedy. This bill sets out a remedy. Newell also says, let's defer to the legislature. He's asking the legislative body, if y'all want to do something different, then do something different. And that's exactly what this bill does. And what this bill does, number one, prevents gamesmanship. Number two, what it says is if evidence that's unknown to the prosecutor is utilized or is not disclosed, then it has to be either prejudicial to the defendant or the prosecutor has to withhold it in ill will, right? There has to be some type of a scienter, is what Newell refers to it.
Okay. Any questions, members? Ms. Jones?
Did I just hear you say that this prevents gamesmanship?
Which one?
You just said that this bill prevents gamesmanship. Did I heard you say?
I don't think anything will eliminate the gamesmanship that criminal defense attorneys use oftentimes, whether it's through discovery, whether it's through delay, whether it's through a lot of other remedies. Frankly, I think I've testified in another hearing, I am a former practicing criminal defense attorney. So even though I've been the elected district attorney for 17 years, prior to that, for a decade, I was a criminal defense attorney. And at that point, the oath that I have taken as a prosecutor to seek justice, as a criminal defense attorney, there was no oath. The only oath you take is when you become an attorney. And so the duties as a prosecutor are completely different than the duties as a criminal defense attorney. Whether you want to call it gamesmanship or whether you want to call it strategy, the rules of evidence have been used in such a way to gain an advantage. And so weaponization, yes, of course. Of course it is being used by the defense.
So let me say this, the prosecution has gamesmanship. They hide, right, and if you use the rules of evidence, it's using the rules of evidence. And I actually respectfully take umbrage with the fact that if I keep something out of evidence because the state didn't prove its authenticity or the state withheld it, that's not using gamesmanship. It's following the law, right? And you have the burden. The state has the burden beyond a reasonable doubt. It is not my fault. It is not my client's fault if you don't have your house in order, where the police are hiding, whoever's hiding evidence. I've had district attorneys hide evidence, and then when I told the district attorney, "Oh, I'm gonna file a motion to have this case thrown out with prejudice," the DA hurriedly dismissed the case because I found out about evidence that was hidden. So I think there's enough gamesmanship to go around, if that's what you want to call it. But, I mean, this literally, do you disagree with me that this shifts the burden and the state gets to decide what's relevant?
I think that perhaps you've misread the bill, and it's clear that you hadn't read Heath, and that's not a shot at you. On the other hand, Heath, as the original witness testified to, Heath was specific to the facts of that case in Waco, and it was a 911 call. Your second question that you've
I
asked
didn't
me
ask
is,
about Heath. I
does
asked
it
about
shift
the
the
bill.
burden? Right.
I didn't ask about Heath.
No, it does not shift the burden.
And by the way, I have read Heath.
It does
right?
not shift the burden.
What do you mean it doesn't?
You've asked me if it's my opinion. I'm telling you my opinion. It doesn't shift the burden.
It says the attorney representing the state.
Correct?
The attorney representing the state, where did it go? They can file a motion after a hearing at which the applicable counsel for the state and defendant are present that may limit a defendant's request for discovery under this article if the court finds that the request is unduly burdensome or implicates the security and privacy interests of any victim or witness, and the document, item, or information was not shown to be reasonably necessary to the defense. So why does that not shift the burden where the state gets to decide whether they think it's unduly burdensome? If there's a million pages of evidence, that isn't a burden, that's the Constitution. It requires that you turn it over. I mean, me having to go and look at something that you gave last minute is unduly burdensome for me to go try to run down all the rabbit traps that might be in all these documents. Rep. Little talked about, I don't know how many he said, 4,000 documents or, 400,000 documents that they're getting stuff. That's unduly burdensome, and it flies in the face of the Constitution. So I'm just trying to figure out how you don't see where this shifts the burden and the state gets to decide whether evidence is relevant or not.
Okay. If you
Yes,
want me to address
please.
that, okay. So now that I know where you're talking, so Senate Bill 1124A2 on a motion by the attorney representing the state and after a hearing, which means a court, at which applicable counsel for the state and the defendant are present, the court may limit a defendant's request for discovery under this article. And so when you're saying that the burden is on us, or somehow or another we're going to hide it, it's clear that what the state is saying is, hey, judge, this is too much. We have to then go in front of the court, and the court would then say, all right, well, how much is too much? Whether it's a quantitative amount or a qualitative amount, and then the court makes the determination at that point as to whether or not the request is unduly burdensome. And so, for example...
Curious. I was talking about HB 3330. Are you talking about something other than HB 3330?
I'm sorry, that was the Senate bill version.
I need
It's-
HB 3330.
Yes, ma'am. I'm trying to think where that was the Senate version, but I assume that the language is similar. But I will if I can pass on that one, and
Okay.
somebody else. Thank you, Jillian. Thank you.
And I
Rep.
knew
Jones.
I knew you way a long time ago,
Yes,
before you were the elected DA.
Yes, ma'am. And
So-
you know, this is the weird thing about this panel is it's kind of fun. Almost several people in here I consider personal friends that I practice criminal defense law with. There's my
Georgia
original
Virginia.
supervisor, Nicole
And
Hodgeclaw,
Nicole?
past president of TCDLA. Almost everybody in here, we're all practicing attorneys. These are things that we deal with all the time. However, the rest of this council, the rest of this committee, this is a knife fight. It's actually a pen fight between two people in a dark alley that nobody else is paying attention to. It's just you and I, because it's a discovery issue. And what it does, Heath says, hey, legislature, y'all fix this. Y'all fix this. And they do. And they just set out a set of rules that say, hey, look, if you're going to go to a suppression issue, then the court has to find that the prosecutor had the information, they held it in bad faith, or that it caused prejudice to the defendant. It doesn't affect the Michael Morton Act in the sense that now all of a sudden you talk about the constitutional rights. I was there. Nobody wants what happened to Michael Morton. Like Mr. Pleasance, I practiced when it was an open file policy. You'd come over to court. We'd be in county court 10. You look at the file. And you go, well, I don't think you got it, Brett. We go, all right, well, let's try this thing. Right? I mean, 3914 as written is beautiful, but it was flawed to begin with. And everybody knew it was flawed to begin with.
But 3330 actually does change Michael Morton. It changes things that are required in Michael Morton. It changes it, but I get if you don't want to admit it. And I understand why you're doing it, because
No,
you want the advantage.
What I want is on behalf of victims that if they have evidence that should come before a court, if the prosecutor is not withholding it in bad faith, and if it doesn't prejudice the defendant, then at that point, the court has to make a finding. I'm here for the victims. When you say I want an advantage, we don't even keep. I couldn't tell you how many cases we win and how many cases we lose. What I as a prosecutor, how I evaluate prosecutors is on preparation and presentation. My favorite prosecutor lost 7 in a row. Preparation and presentation. That's something that as a supervisor that I can look at. Hey, did you talk to your witnesses? Did you do all those things? So you say it's a victory for me. My job is to seek justice. A dismissal, to me, is just as good as a conviction, depending on if the facts are warranted. You also have to understand, not have I been a criminal defense attorney, at the very next election, I could be a criminal defense attorney again. I'm willing to operate under these rules because these rules are not unfair.
Well, I'm defending the Constitution
There's no,
and its amendments.
I respect that. I do too. I do too. I love the Constitution. I love the Fourth Amendment, the Fifth Amendment. The Second Amendment is probably one of my favorite.
Any other questions? Members, any other questions? Mr. Little?
District Attorney Ligon, I think you suggested that Representative Jones had perhaps misread the bill. Perhaps I misread it as well. Okay?
Well,
I'm reading, my understanding is this is an amendment to Article 3914, which is the Michael Morton Act. First material change appears on, to me, page 2, striking out material to any matter involved in and replacing it with relevant to any fact of consequence in determining. So let me dovetail my comments to what Representative Jones had said. I won't call it shifting the burden, but what it allows the prosecution to do is make its own determination of what is relevant before producing that information to the defendant. Will you agree with that?
I was looking for your answer.
Yeah, we're at the top of page 2 of the bill. Do you have the bill in front of you?
Yes, sir, I do.
The modification is to insert the language relevant to any fact of consequence in determining
Yes, sir, I see.
the
it.
action.
Yes, sir.
And the way I read that as a civil lawyer, I deal with the same terms, relevance, materiality. It's applied pretty uniformly across all areas of legal practice. What's happening is the prosecutor gets to make its own determination of what's relevant before producing that material, right?
Right, because it currently says material, and this bill changes it to relevant
Right.
because of a case that came out called Watkins versus State.
I'm glad you brought that up because I got that case in front of me. It's 2021 Texas Court of Criminal Appeals case. Let me read to you from it. It says, under Article 3914H, the state has an affirmative duty to disclose any relevant evidence that tends to negate guilt or mitigate punishment, regardless of whether the evidence is material under Brady.
Yes, sir.
So my understanding of this holding in Watkins is state's got to produce it regardless of whether it's material for purposes of exculpatory evidence, right?
Yes, sir. Yes, sir.
Yeah. So when I read the modifications that are expressed in Representative Cook's bill, what I'm seeing is the state gets to decide whether this information is actually relevant to a fact of consequence before deciding to turn it over. Don't you agree?
Yes, sir.
Okay, I got a problem with that. Because to be quite candid with you, DA Ligon, I experienced the same thing in my civil cases when I'm seeking information and discovery and the other side says, well, I don't think that's relevant, so I don't have to produce it. Well, that's not the standard for discovery. The standard is whether it's reasonably calculated to lead to the discovery of admissible evidence in a civil case. And that's when we're just talking about money, not somebody's life. So these are the problems that are, these are the problems that surface based on my reading of the bill,
Sure.
which I think I'm reading it correctly, and I think you've confirmed that I do, or I am reading it correctly. Let's just move on to A2 for a second, dealing with the scope of discovery. And my understanding is the district attorney's office is asking the legislature to limit the scope of a defendant's discovery, or at least allow a court to limit the scope of a defendant's discovery, right?
Yes, Your Honor. Oh, yes, sir.
Why do you want to do that?
Because oftentimes the request is nothing more than a,
Fishing expedition?
yes,
Okay.
or not just a fishing expedition, but for example, if the request is, okay, I want every offense report ever generated by every officer in this agency, that would be unduly burdensome, right?
Yeah.
For example, if I've got a criminal trespass case and I'm a defense attorney, and if there is no way to corral the request, then a request that is not specific as to time or date or even remotely connected to it, then every request that the defense would make, now all of a sudden the state would have to comply to, regardless of the scope of it, and regardless if it had anything to do with the case or not, because what it's seeking to do is then put it in front of the court to say, okay, all right, I get it, I understand the argument. You're saying it's a trespass case. You think perhaps the officer's lying. Maybe every offense report that officer generated, but not every offense report that every officer ever generated at any time with this agency. So there has to be a way to corral the overburdensome nature of it.
I'm not sure there does. So in a civil case, I don't have a right to a speedy trial. Some of my cases, it'll take 5-6 years for me to get in front of a jury. In a criminal case, you can be trying that case like that. And of course, you're going to want the galaxy of information that you could possibly get that might help you represent your client. So very big difference there. How many bad guys are walking the street in MoCo because you didn't limit their discovery?
How many?
How many people were you not able to successfully prosecute who you felt like this person committed a crime? If only I had had these changes to the Michael Morton Act.
So you're saying, I'm trying to get to the heart of your question. You're saying is, hey, if I don't get this change done, is it going to affect criminal justice in Montgomery County?
Yeah.
To the degree that evidence is suppressed, then yes. To the degree for a county like Harris County, Dallas, Travis, there's an implication that all the judges are the same. There's an implication that all the judges are working with correct intent. And so when you have a jurisdiction where the judges aren't and they're looking to get out of cases, then all of a sudden you take a case like the way that Heath is and you read it in such a way. I think in Montgomery County we're doing pretty good. I hope that we catch all the offenders. On the other hand, if we're subject to a suppression issue that is not appropriate, there's no prejudice to the defendant, the state was unaware of it, and it was a child sexual assault case, and that kid didn't get a fair shot at trial, I mean, it'd be upsetting.
I'm not talking about hypotheticals. I'm talking about in Montgomery County where you work, where you've been elected. How many bad guys are walking the street that shouldn't be because of a suppression issue, do you think? Can you think of any?
We have evidence suppressed. I'm not sure what you're,
My
if
point
you're
is,
saying, do we lose cases because evidence is suppressed? Rarely.
Yes.
If that's what you're
can
getting
you
at.
think of one?
Can I think of one off the top of my head? Yes. I can tell you one, we're litigating one right now. It's a pro se defendant, and the judge granted a motion to suppress on, there was the drugs were in the court, the physical evidence. The defendant knew that the drugs were his. He knew that he was charged with, and the prosecutor had a picture of the drugs.
Uh-huh.
And the judge decided to grant a mistrial because of a Michael Morton violation.
Yep.
Even though the defendant is looking at the drugs, it was the picture of the drugs that are sitting right there that the
was not
judge ruled
disclosed.
to be a violation of Michael Morton, and then granted a mistrial over that particular issue. And so had that been subject to this, hey, there's no prejudice. The defendant knew about it, number one. Number two, there's no ill will on part of the prosecutor. So there couldn't have been any prejudice to the defendant because it was the picture of the drugs that were sitting right there.
Uh-huh.
Yes, that is annoying to no end. And those prosecutors are facing a bar grievance. Now, I don't know how far it'll go,
Sure.
but yes. Yes.
My suspicion is that for a county like Montgomery that is well-run, your office is well-run, that this is probably a solution in search of a problem. But if we're getting to the heart of the issue, it sounds like you're concerned that other counties, Harris, might perhaps have judges where they're going to go, oh, easy out, suppressed, dismissed, and you're concerned about them exercising their discretion to do that. Is that possible? Is that the heart of the problem?
You know, it's a state bill, and of course it would have an impact in Montgomery County as it would have an impact in any other county. And so as a prosecutor, I also prosecute in every county in the state of Texas in which another elected official recuses himself. And so at this point, I've probably prosecuted in 17 jurisdictions. And so the bill, if it's fair everywhere. And so whether it's a capital murder down in Del Rio, or whether I'm doing human smuggling in Bracketville, or whether I'm putting a sheriff in his own jail in Waxahachie, as a state prosecutor, according to the law now, if somebody's recused, then it has to be another state prosecutor. And I, have pen will travel. And
Yeah.
so the law, if it's applicable everywhere. And so it's not just about justice for Montgomery County. It's not just about justice for victims. It's about an equal application of the law in any jurisdiction.
Yeah. So one of my concerns is this feels like when the statute came into law, the Michael Morton Act, the DA supported that statute, right?
Of course, to the degree that we would like to, there was, everything from reciprocity to it. It was supposed to be a mirror document. 3914 had the exact same discovery rights for the state as it did for the defense. And so, of course, like most bills, for example, the relevant versus material, I don't disagree with you. I don't disagree with you in regards to the relevant versus material. I think that was a committee drafting to try to reconcile it with Watkins.
Okay.
But we'd love to work with you on that issue. I don't think that is an issue that somebody's going to go, oh, if we don't win relevant versus material, take it back to material. It puts us right back where we were. So it's not a fatal issue.
My main concern is that the statute is borderline sacred right now. And there's a good reason for that because of what happened to Michael Morton. And so the pendulum swings. This was a horrible event. We must respond in statute. And then the pendulum swings back. The DAs go, this is really hard. We want to loosen it up. And I think we need to remember why this is here in the first place, that this can have cataclysmic effects on someone's life. And so I think I'm rightful in expressing some skepticism about the movement of the statute. Maybe you disagree.
No, I mean, the statute is sacred as anything that is flawed that you revere because it's a symbol. The statute, but there's a real person But the statute never had a remedy for a suppression issue. And it's not me saying that, it's Heath saying that. 3914 has never included a provision concerning the remedy for a discovery violation.
And so what should the remedy be, DA Ligon?
Well, I think the remedy should be, at least when it comes to the suppression of evidence, there should be, number one, if it doesn't hurt the defendant, first, and then secondly, if there's not a showing of bad will by the prosecutor, what this is asking for is a continuance. Or it's asking for a protective order. It's saying, hey, let's get to a reasonable remedy. Ms. Jones said that she couldn't review or if you're in trial and she's like, man, I don't know if I have enough time to review a 911 call. You know, I may argue with that. Sometimes you can, sometimes you can't. Sometimes a 911 call is nothing more substantive than you need to get an officer out here. That can be reviewed fairly quickly. Other times, if it goes into something substantive and all of a sudden it lays out the elements of defense for your client, you may want to go back and investigate it. But what it's saying is, court, before you can suppress that evidence, you should consider the continuation first to give the other side the opportunity to review it before, I'm sorry.
And I will just say, I think you're right about that. Right? I mean, your comments are over the target as far as what I understand the bill to be expressing. These terms are very familiar to me as a civil lawyer.
Right.
Because when you have something that happens late in a civil case, the court turns to the questions of, is there unfair surprise and undue prejudice? And can I cure this with a continuance? We're just talking about money in a civil case. This is very different. You're talking about somebody's freedom.
Absolutely.
And it's hard to imagine getting right up to the edge of a trial where we're literally talking about your freedom. And then you're like, oh, here's a new piece of evidence. Judge just goes, oh, well, you just want a continuance, right? I mean, that's a hard conversation to have at that point.
I
At least it is
understand
to
your
me.
concerns. Yes, sir.
Thank you.
Any questions? Ms. Jones?
Now, you know there's other people behind me. You don't have to
I
get them all out.
understand that, but you
at
said
once.
something. So like even with a 911 call, let's say you give the 911 call 4 years later, right? Some kind of way you figure out you had
Sure.
something, you know you had it. There are people in that 911 call that may not even recall anything now because it's 4 years later. There may be somebody in the 911 call that maybe died that could help my client, except for I don't know that because I didn't get it for 4 years. So, like, things happening at the time they happen, you're just more likely to get more reliable information. You're more likely to track down potential witnesses in that 911 case. So sometimes it's not always obvious when you get it at the last minute that it could lead to something material or something relevant. And therein lies my problem. And I also, again, the state has, I guess, skin in the game, for lack of a better word, in that you have to prove your case beyond a reasonable doubt. And as you said, that you are fighting for the victims, and I respect that, except for justice takes society into account. Justice takes the Constitution into account. And so there's more than just that. So this bill, no matter how well-intentioned, even if it's looking for clarity, actually erodes away Michael Morton, which you said was sacred. I mean, I heard you say that it's almost sacred.
Sacred but flawed. I mean, I was there when it occurred. I was there during the negotiations. I've been there ever since as a practicing either defense attorney or as a prosecutor. And so just because it's something that was necessary at the time didn't mean it was a perfect vehicle. There was every legislator we spoke to at the time that recognized it was not a perfect vehicle and it was going to require it to be amended.
Would you agree with me that if there's a tie in a criminal case, it goes to the accused?
Goes to the defense, absolutely. And
Okay.
it should, it should.
Okay, well,
Of course.
if there's a tie and they give me some information last, the tie goes to the defense.
So I was trying to track the language that you were trying to get to with the 911 call, because my first concern was that you were saying, hey, look, if the state holds it, because my response at that point goes, well, the judge has still got to make a determination of probative versus prejudicial, right? So even if it's turned over. And I was trying to follow your train when you were talking about that if it occurred 4 years previous to it, and you just now found about it, there could have been evidence or what have you. And I understand that, But if that evidence, I'm still struggling with the part that dealt with the suppression of the issue. That would be that the tape would, or that the 911 call would be trying to come in, right? And so the prosecutor, if they don't find out about it till 4 years later and they try to disclose it, this prosecutor, 6 days before the trial, finds out about it. She discloses it. Defense files a motion and an appeals at that point. And so I was trying to overlay or make the comparison between what you were saying about if something happened 4 years before and you didn't discover it, that there could have been evidence that you didn't retrieve, but neither would the state.
But my point is, the state almost always gets the 911 calls. If the state didn't discover the 911 call until 6 days before trial, that's the state's fault. The state didn't do whatever the state was supposed to do to get that information. And if I'm an accused person and I've been waiting for 3 years, 4 years, 5 years to have a trial, a continuance means that I have to wait until whenever it's continued. That's still not fair to the defendant.
Right, and I don't think you and I are arguing about that. I mean, it's justice delayed is justice denied for anyone. I mean, we're talking about a vehicle that Newell asks for, that Heath sets up and asks this legislature to create. And so if the legislature wants to continue to defer to a judge and the judge is saying, hey, we need some insight, 3914 doesn't have a remedy. It doesn't have a remedy.
But
We've got a bunch of
Okay.
witnesses we need to call. We've kind of worn you out, I think.
I've always enjoyed my conversations with Ms. Jones, so.
Any other questions for Mr. Ligon? Okay, appreciate you being here.
Yes, sir, thank you.
Your durability.
Oh.
So the chair would call Troy McKinney. And Mr. McKinney, you've registered on behalf of yourself against the bill. Your name's Troy McKinney. Is all that correct?
That's correct.
Okay.
Some of you know me, some of you don't. I was intimately involved in both the negotiations and the drafting of much of the language that turned into the final Michael Morton Act bill. So much so that at one point I got a call from Senator Ellis's office that said, if the restrictions that are being imposed in this bill are too much, tell me and we will kill it. And my answer was, no, don't kill it. The sky is not falling because of the Heath case. Before the Michael Morton Act, the process we went through for discovery was we filed motions in every case because there was no right to discovery. We filed a motion, we went to the judge. Judges got tired of hearing the same motions over and over and over again. The judges would enter an order. And there were two kinds of judges. Ultimately, there would be judges who would say, if you don't follow my order, I'm going to exclude the evidence. And other judges that would say, no, we're going to find other remedies. That, and then some in the middle who would determine what to do based on the individual facts and circumstances. That's not any different than what's happening now. Heath is not, the sky's not falling because of Heath. Judges have always had discretion to make rulings based on the facts and circumstances of the case. And all Heath said was the facts and circumstances of that case were within the judge's discretion, the same way it was before the Michael Morton Act. I think, with all due respect, Representative Cook, this proposed amendment to this bill kills the Michael Morton Act. But prior to the Michael Morton Act, we could ask for anything we wanted. The judge granted it. We got it. This bill, the way it's drafted right now, limits the state's discovery just to anything in the prosecutor's personal possession or in the law enforcement agency who investigated its possession. If it's not there, we have no right of discovery. That's less than what we had before the Michael Morton Act. I've created a list of 15 items off the top of my head, and I'll pass these out, of things that would no longer be subject to discovery in criminal cases. I don't know.
Okay, let me see, just hand it to her. Any questions, members?
yeah, I'd like to see, I don't know what he has.
It's a list. The list is 15 different categories of items of evidence that occur in lots of different cases that would no longer be subject to discovery because they're not something that was created by the investigating law enforcement agency or something that was already in the prosecutor's possession.
I'd actually like for you to go down this list because I think it's important for it to be heard by the people that aren't privy to what we have handed out?
The autopsy reports and death investigations by non-law enforcement
And
entities.
can you put this to, you're sort of tall, and it's
Okay.
hard to hear sometimes.
Autopsy reports and death investigations by non-law enforcement entities such as justices of the peace or inquest would no longer be subject to discovery requests to the state. Statements of a complainant related to the offense and the application for crime victim compensation funds would not be subject to disclosure because they weren't in the prosecutor's possession and they weren't in part of law enforcement's investigation. 911 calls, the Heath situation, would no longer be subject to a discovery request. Ambulance, fire department, other governmental records, but not law enforcement first responder records, would no longer be subject. I can't tell you how many times ambulance records or first responder records have become relevant to a case. Those would no longer be subject to discovery because they're not either in the personal possession of the prosecutor, nor are they in the possession of the law enforcement agency that investigated the case. There's a whole list in item 5 of non-law enforcement crime labs, or labs, that conduct investigations and lab analysis. None of that would any longer be subject to discovery under this amended version of the Michael Morton Act, because those are not law enforcement entities, and that's information that's not in the personal possession of the prosecutor. Juvenile cases, where the school district people interview kids and parents in the process, that would no longer be subject to Michael Morton Act disclosure under this statute. Because they're not law enforcement, they're not in the personal possession of the prosecutor. Comptroller sales tax investigations, CPS and Adult Protective Services records, government hospital medical records and psychiatric records, statements and testimony in Title IX proceedings in state schools. I could tell you a story where that mattered. SANE and CAC records, including witness statements that are part of those records, would no longer be subject to discovery. The state could hang on to them and use them for the first time during trial without it ever being disclosed to the defense. TCOL records and personal records on offense reports for officers that did not investigate the case but were involved in the detention or arrest. It's not uncommon for be multiple agencies out there that don't write reports and don't do the investigation. And the last one is extraneous offense evidence that obviously would not be either in the personal possession of the prosecutor, sometimes it might be, or certainly not the law enforcement agency that investigated the case at trial.
There were two you sort of read over, but that you didn't say. TABC administrative regulatory investigations.
Yeah, by way of
which you have as
example.
number 7, and then Texas Workforce Commission records.
By way of example, the TABC, almost any time, there's an accident involving a death where alcohol is involved. If TABC is notified, which is frequent, and they know where the person had been drinking, TABC goes out and conducts an administrative investigation of the establishment that served the alcohol. They interview witnesses, they produce reports. Those are discoverable now under this version of the House bill, and the Senate bill are the same way. That would no longer be discoverable because they're not doing a criminal investigation. They're doing a civil administrative investigation to find out if the establishment should be sanctioned for serving somebody too much alcohol or serving an intoxicated person.
May I ask you another question? In the current version of HB 3330, what specifically, if you've looked, caused you concern?
My biggest concern is the definition of what the state is. The state has always been the state of Texas and all political subdivisions, entities, and agencies under it. That's the definition that was intended in the Michael Morton Act. That goes away with the proposals in this bill because there's lots of things that aren't in the possession of the prosecutor or aren't in possession of the law enforcement agency that investigated the case. I can't tell you that nobody ever plays games. That certainly happens. But judges have the same discretion now with the Michael Morton Act that they did before the Michael Morton Act when it came to making a decision about whether to exclude evidence or grant continuance. Before I came up here this morning in another county, I won't say where because it doesn't matter, a 4-year-old sexual assault case that I've been asking for information for the last 4 years. We were set for trial 2 weeks from now, and a week ago, I got a list of 20 some odd different witnesses none of whom were previously mentioned in any of the discovery I got on that case, not a one. We continued it. That's what should happen. But frankly, if I decided to throw a fit, the judge would have had the discretion to say, you know what, after 4 years, it's too little, too late. There was a case in San Antonio, not my case, somebody else's, where the defense had affirmatively, years earlier, asked for a speedy trial, and some discovery had been requested along with it as well. There had been repeated instances of, oh, we're going to produce it, oh, we're going to produce it. It never was. And finally, it got to the point where the defense lawyer in that case in San Antonio went to the judge and said, so which constitutional right is my client now going to have to give up? Is he going to have to give up his Sixth Amendment right to a speedy trial that he's been begging for the last few years? Or is he going to have to give up his right to get the discovery to defend his case? It's the Hobson's choice. In other contexts, the Supreme Court of the United States has said you can't make people give up one constitutional right to enforce another one. Yet that's exactly what would have happened until that judge had the courage to stand up and say, you know what, I'm going to dismiss this case for speedy trial violations. That dismissal of cases is an exception, not the rule. I have not seen any case, nor do I think a judge has any power to dismiss a case merely for a discovery violation. The judge does have discretion, and always has, before the Michael Morton Act, now, although it wouldn't have any discretion afterwards, or very limited discretion afterwards, to exclude evidence when the judge thought it was appropriate. It's not new, but this bill wants to try and take what's been working well for the last decade plus, better than it ever had been before, and decide that because there's a judge here, a judge there, that we don't like the rulings on, let's try and change the whole thing. And that's not the way sausage should be made. The Michael Morton Act, speaking of which, the idea that there's no sanctions in it. The committee substitute, the initial committee substitute that came out had sanctions in it. It was part of the negotiations between prosecutors and defense lawyers in a room in the basement of the Capitol. We spent 4 or 5 hours down there hammering this out. It would have allowed a judge to hold a defense lawyer or a prosecutor in contempt, sends them up to 6 months in jail for failing to comply with the requirements under what was then the draft of the Michael Morton Act. Not surprisingly, neither defense lawyers nor prosecutors were really thrilled about that idea. Yeah, until you're on the losing end of it. It would have, for example, if a defense lawyer, back when reciprocal discovery was still there was a deadline for giving notice of an alibi defense, and if the defense lawyer didn't do it, the judge could find the defense lawyer in contempt. That certainly doesn't further justice, doesn't have anything to do with the person on trial. There could certainly be a way to outline lots of potential options, but ultimately it's still going to come down to a judge's discretion. As a prosecutor said to me today, and these are his words, not mine, there comes a point where the legislative branch needs to let the judicial branch just do their job. His words, not mine. That was an elected DA who told me that today. Michael Morton Act's working well, and isolated instances where a judge decides to exercise discretion to exclude evidence is not cause, is not justification for throwing the baby out with the bathwater, which is what would happen if this bill passes.
Rip Little.
Yeah, thank you, Chairman Wu. Mr. McKinney, I want to make sure I understand this. You used the phrase in your testimony, again, personal possession of the prosecutor, and I think that the source of your concern is the addition of the language attorney representing to the state. Did I read that correctly?
That's correct.
Okay. So you read that very differently than I did. When I was reading it, the way that I read the addition of that language was to essentially quarantine the bad actor attorney, the agent of the district attorney's office, from communicating by contagion all of his bad acts to anyone else who might prosecute the case. But when you read that, you said, I am now quarantining the discovery obligation away from the entire state who might prosecute me. Am I
Correct.
stating that correctly?
You are correct. It limits it only to the obligation being, if the prosecutor has it, if it's in their possession, then and only then do they have to produce it.
Okay. And I heard District Attorney Ligon earlier talk about we need to craft a remedy, we need to craft a remedy. I'm looking at the end of this bill, and the remedies are still up to the court's discretion, aren't they? I mean, that's how
They
I
are.
read the word may. Court may suppress evidence. The court may grant a continuance. I mean, is that how you read it as
That's
well?
exactly how I read it. It's still discretionary.
But they've got the discretion now,
I agree.
right?
Absolutely.
And in any case, civil or criminal, when you violated, the court is weighing the harm. They're weighing the surprise and prejudice on the parties in crafting that remedy or crafting that discretionary remedy, and then the appellate court is reviewing it for an abuse of discretion. Isn't that right in the criminal context too?
Yes, even a higher standard than abuse of discretion, but generally, yes.
What's the standard in a criminal case?
If there is any factual basis to support the judge's decision, then the appellate courts are bound to uphold the judge's decision.
It's a pretty dang high standard. Okay.
There has to
Thank
be
you.
evidence to support it.
Thank you.
And no matter what kind of sanctions were put, there would still have to be evidence to support it.
Okay. Thank you, Mr. McKay.
Members, Rep. Cook.
So going back to your discussions from, I guess, 2013, I mean, so if a defense lawyer or a prosecutor were to act in bad faith, you don't think contempt of court should be an available remedy?
My short answer is no, I don't think contempt should be.
Okay, tell me why.
Because we don't, absent more than just,
I said if the court makes a finding that, not you, but
I understand.
Attorney X, if the judge makes a finding that the attorney has acted in bad faith, you do not believe that contempt of court should be within the judge's discretion?
I think there has to be more than just that for a judge to find somebody in contempt, a defense lawyer or prosecutor. I think there has to be more than that. It has to, in some way. I can conceive of a situation where a judge could do that currently. I think it would be a rare exception where that actually happened.
Would it also be rare for, like, this list that you gave here, would it be rare for, for a prosecutor not to have a 911 tape in his or her file?
It would be uncommon for them not to have it.
Okay, so that's,
I've seen.
this seems to me to be like a misrepresentation. Maybe it's not.
How so?
What I understood from you to say is that you would no longer be able to get this information. So I just can't imagine a prosecutor would have a 911 tape available and it not be in his or her file just so that they could, quote unquote, hide it. That's what you're saying, right?
No, what I'm saying is the prosecutors would no longer, if I write out a list, and let's say all 15 of these applied to my case, which would never happen, but if all 15 did, the prosecutor could now say, you know what, I don't have any of this stuff. There may be some other state agency, some other.
But let's just hone in on 911 calls and autopsy reports. You think that that a prosecutor is not going to have those types of, let's say it's a murder situation, and there's been an autopsy performed, and you just made the representation to to this committee that autopsy reports are no longer discoverable. That's what I understood you to say.
They're not discoverable from the prosecutor, yes. I tried a case in December where the prosecutor had the autopsy report and never produced it to me. I got it otherwise. I didn't raise any issues about it because it really didn't matter in the case.
But did you ask for it?
I did. I asked for the autopsy.
Okay.
It was a manslaughter case, and I did ask for the autopsy. It never got produced, but it didn't matter to the case.
And I have the same disadvantage that Representative Little has. I'm a civil lawyer, not a criminal lawyer. So y'all wouldn't file a motion. Is there not the equivalent of a motion to compel or something like that?
Could I have done that? Yes. I did not do it because frankly it would have been just a waste of paper because I was able to get it otherwise on my own.
Somebody's life's at risk. It seems like you would avail.
No, lawfully. There were some parts of it I could not get without a court order, but there are autopsy reports are generally public records.
So on the case that you talked about earlier, where you said that I believe you said it was a sexual assault case. It's been pending for a long time. So, and you just got notified of some was it witness list, things like that?
Yes, witness list plus some other things. Yes.
So if that becomes, and we'll make it a hypothetical, but if that becomes a situation where it would be impractical or impossible for you to properly prepare for trial, what would be your remedy? What would you go ask the judge for?
Then I think I would go back to the judge and say exclude evidence. I didn't do that today. We continued the case. The case was frankly probably going to be continued anyways because we were still well down the trial docket. So the suggestion, do some lawyers on both sides play games? Absolutely. That is not the common thing,
What's not common?
playing games.
So, I mean, would a continuance, I mean, you said that's basically what happened, but I
Yeah.
mean, would that be a remedy that you would also, I mean, if you weren't successful on a suppression or excluding, would a continuance be the next, next choice, I guess?
I think
That
it's
you
the
need
other
more
way.
time?
I think it's the other way around. I think the default option generally is that a judge, if a continuance will cure the problem, that's what a judge should generally do to begin with. But if a situation arises, I'll just give you an example. This wasn't a trial; it was a hearing. But in the middle of a hearing, I had a prosecutor. I guess it was 21, 22 during the pandemic. Actually, try and offer an affidavit from Toll Road Authority into evidence that they had for over a month based on the date on it, that they had never given to me. In the middle of this hearing, I said, "Time out, Judge, this has never been produced to me." And the judge didn't miss a beat and said, "It hadn't been produced, it wasn't coming in for other reasons anyways." The judge said, "Hadn't been produced, it's not coming in as evidence." They'd had it for a month and had never turned it over.
Do you agree with the earlier comments that, I believe it was Judge Newell, I mean, the prior district attorney, Montgomery County district attorney said that he felt like Judge Newell was asking for a remedy. Do you agree with that?
I think Judge Newell was saying that if the legislature wants specific remedies, then the legislature has to do that. Short of that, the judge is going to have a great deal of discretion to fashion the remedy they think is appropriate. And if the judge makes a ruling that is not appropriate, both the state and the defense have remedies to that.
But I'm asking you, I mean, in your reading of the Heath case, do you believe that Judge Newell was asking the legislature to take action in this regard?
Honestly, it's been a while since I've read it, and I don't know that I could answer that truthfully without rereading it.
Fair enough.
I don't know.
Thanks for your
Short answer.
testimony.
Okay.
Any other questions, members? No, thank you for being here, Mr. McKinney. We appreciate it.
Thank you all for having me. Always happy to be here. And I hope it's another 10 years before I have to come back.
And Briscoe Kane, one of our House members, said that he taught you everything you know about criminal law. Is that correct?
He was a runner in our office before he went to law school.
The chair calls Anna Vasquez. And you are Anna Vasquez, Director of Outreach for Innocence Project of Texas, testifying and on behalf of yourself, correct?
That's correct.
And you're against the bill.
Correct.
Go ahead.
Thank you, Chairman and members of the committee. We've been talking a lot about the Michael Morton Act, and I am in opposition of that. I am here as the Director of Outreach for the Innocence Project of Texas, but I also am the President for the Innocence Network Executive Board. But before that, myself and my 3 friends spent many years behind bars for a crime that never occurred. In total, out of the 4 of us, we served over 50 years. And the one thing that we don't talk about is, I know that we're trying to get things right and do things the right way, and I don't believe that we are trying to do something the wrong way. I just don't think that we are discussing it as much as we should be. So what I want to share with you, because you're going to hear from the other attorneys, I want to share with you the effects of those wrongful convictions. The fact of, spending 13 years of my life in prison. It started at the young age of 19. At 19 years old, we should start life. We should be enjoying life, having dreams, going to college, fulfilling those dreams. And at the young age of 19, my name was ruined. Going to prison, I lost family members, spent many years watching behind bars, parents, grandparents dying, children growing up, and I'll never get that back. So I firmly, humbly, respectfully ask you to oppose this bill.
Okay.
Thank you.
Thank you, Ms. Vasquez. Any questions, members? We certainly appreciate you being here. The chair calls Amy Waddle, Assistant District Attorney. you've registered as on behalf of Montgomery County District Attorney's Office and yourself, Amy Waddle, and you are for the bill, correct?
Yes, sir. Thank you, Mr. Chairman, members. My name is Amy Waddle. I'm an Assistant District Attorney in Montgomery County, Texas, where I am the Chief of our Appellate Division. I want to begin by briefly addressing this issue of relevance. That's not what this bill is about. This bill is about restoring the requirement of rational remedies for discovery issues or errors that happen. The change to relevance in subsection A1 is literally just a codification of what the law already is, because courts have already interpreted the word material in current subsection A to mean relevant. So by codifying that, it is not giving prosecutors any additional power to unilaterally decide what is or is not relevant. In fact, the bill specifically requires that if prosecutors believe something that has been requested is not relevant and discoverable, they have to go to the court and get the court to decide that dispute at a hearing where both sides are represented and get to make their case for why this is or isn't relevant and discoverable. And that subsection is specifically geared towards situations involving voluminous, like scientific evidence, laboratories, where we're seeing defense requests for just a myriad of things that don't reasonably relate to the issue on trial, and it's just it's bogging us down. And then what we're seeing as a result of Heath is instead of moving to exclude the whatever piece of evidence or item, not even evidence necessarily, was not disclosed, they're moving to exclude the entire witness's testimony, regardless of whether that testimony was actually affected by whatever document they requested that might be theoretically relevant that was not disclosed. So the change in subsection A, though, is not what this is about. This is not about limiting defendants' discovery rights. It's about limiting trial court's power to punish the community for inadvertent and harmless discovery violations. We've heard a lot about situations where a discovery violation actually affected the defendant, but this is not what this is about. This bill would still allow trial courts in a situation where the defense was actually prejudiced by a late disclosure to consider exclusion as a remedy.
Let me see if there's any questions. Any questions for Ms. Waddle? We appreciate you being here.
Thank you.
Chair calls Gary Uderson.
Thank you. I'm Gary Uderson.
And Mr. Uderson, your affirmation shows that you're here on behalf of the Innocence Project of Texas and yourself.
That's correct.
And you're against the bill, correct?
That's right. And I'll just make a few brief comments because I think Representative Jones and Representative Little have covered it. What's wrong with this bill already. I'll just tell you that I am a criminal defense attorney in Dallas. I've been practicing for 45 years. For the last 18 years, I've been a board member and a volunteer attorney with the Innocence Project of Texas. I have been involved in about 30 exonerations in the state of Texas. I was doing this work before the Michael Morton Act. I'm doing it now, and I can tell you with certainty that there are fewer innocent people being convicted now than were being convicted 10, 20, 30 years ago for a lot of reasons, but one of those reasons is the Michael Morton Act. One of those reasons is defendants getting discovery when they should get it and having the opportunity to actually defend a case on a level playing field. And what this bill appears to do is to say there's something wrong with that we're giving too much discovery to defendants and we need to go back to the way it was before. And I can tell you from my personal experience that if we do that, there's going to be some innocent people who are going to be convicted because the legislature went back. And with that, I would just ask you not to do that.
Okay. Any questions for Mr. Uderson? Yes. Ms. Rodriguez-Ramos.
Thank you, Mr. Uderson. So I practice civil, and this is new for me. So it appears to me, and let me know what your thoughts are, that the Michael Morton Act essentially simplified the process and made everything more efficient in terms of hand over what you have and we just exchange information. it seems to me this complicates a little more, allowing each prosecutor to decide what information they wanted to produce. It seems that would make it difficult for the district attorney's office to really control all of this if each prosecutor is deciding what is relevant to any fact or consequence in determining and handing over the information. Is that how you read it as well?
That's exactly right. Before the Michael Morton Act, every prosecutor created their own standard for what they were going to give the defense in discovery. We would go sit down in front of a prosecutor, and they would flip through their file and say, okay, I'm going to give you this. Oh, I'm not going to give you this. I'll give you this. And they just got to decide for themselves. This bill takes us, it doesn't take us all the way back, but it takes us about half of the way back. And I have not, the Heath thing, the Heath issue is a totally separate issue from the provisions of this bill that directly undermine the Michael Morton Act. Frankly, this is two bills in one, because part of the bill deals with Heath, and part of the bill is a direct attack on the Michael Morton Act. So it's really just a question of, do we think in Texas defendants are getting too much discovery? I mean, do we think we need to give more power to the prosecutors to decide what defendants should get? Because back when I started practicing in 1980, for about the first 30 years of my practice, that's the way it worked. We only got what prosecutors wanted to give us. And that was a direct cause of a lot of the wrongful convictions and people that are sitting in this room today and people all over the state. And nobody has given us any reason why the Michael Morton Act isn't working as intended to try to ensure we don't have wrongful convictions.
So you as a defense attorney or representing individuals from the Innocence Project from this point on or post Michael Morton, no matter, I mean, we're licensed to practice all over the state of Texas. So this allows you to wherever county you're going to represent any individual, there's a consistent standard and expectations and what the prosecutor is going to deliver to you and what you all are going to exchange. Prior to that, it just depended if you knew what county you were in, if you knew the prosecutor and what mood they were in that day.
That's exactly right.
Yeah.
It even varied from prosecutor to prosecutor in the Dallas County District Attorney's Office. This prosecutor was willing to give us more than the prosecutor next door. It was all just very random. And that really, I mean, you know, you heard from Anna, you're going to hear from Richard Miles. There are people who were wrongfully convicted and went to prison who would not have had the Michael Morton Act been into effect. And these provisions that are proposed, they're going to create wrongful convictions. And that should be enough to cause us pause before we go down that road.
Thank you, sir. I appreciate it.
Thank you, ma'am.
Ms. Jones?
Is there anything that you want to say that we haven't asked you?
I don't think so. And I think, Ms. Jones, I think you and Mr. Little, y'all covered it. I mean, there's nothing else anybody needs to say. Y'all covered it.
They're very thorough.
All right. Thank you.
Thank you, Mr. Ocean. I appreciate you being here. The chair calls Burke Butler. And Ms. Butler, you've registered as Burke Butler, Executive Director, and you're testifying on behalf of Texas Defender Service, and you're against the bill. Is that correct?
That's correct.
Thank you.
I agree with the concerns that have been raised already, so I just will make a few points. First, this was a common sense law. In 2013, the Michael Morton Act was introduced to widespread bipartisan support. In a Republican majority legislature, this bill passed both chambers unanimously and was signed into law by Governor Perry just 2 days later, with Michael Morton himself standing by the governor's side. The governor said at that time, "This is a major victory for integrity and fairness in our judicial system. We are known as a law and order state," he said. "But with that tradition comes a very powerful responsibility to make sure our judicial process is transparent and is as open as humanly possible." In that spirit of transparency, this act ensures that every defendant will have access to all the evidence relevant to his guilt or innocence. Prosecutorial misconduct, including withholding key exculpatory evidence, is a leading cause of wrongful convictions in the United States, and the only way to effectively avoid wrongful convictions and protect the innocent is to give the defendant access to the same information the prosecution has. HB 3330 would gut the Michael Morton Act to its core. His case was a tragedy that didn't need to happen. Our justice system must focus on accuracy and integrity, not obtaining a conviction at all costs. Thank you.
Thank you, Ms. Butler. Any questions? Appreciate you being here. Chair calls Mike Ware. Mr. Ware, it's good to see you. You've registered as Mike Ware. You're Executive Director, and you're testifying on behalf of the Innocence Project of Texas and yourself against the bill, correct?
That's correct. Good evening. My name is Mike Ware. I'm here on behalf of the Innocence Project of Texas, and we are against House Bill 3330. I co-founded the Innocence Project of Texas back in 2006, and since that time, we have freed 40 Texans who were wrongfully convicted and imprisoned. Texas, in fact, leads all states in exonerations. This past year, once again, Texas had more exonerations in 2024 than any other state, with 27. Unlike Michael Morton, most of these exonerees are people you've never heard of, in cases you've never heard of. I agree, and so without repeating what has already been said, I agree with everything Representative Jones has talked about, everything Representative Little has talked about, and maybe most importantly, what Michael Morton himself so succinctly stated in his written statement. You know, I don't think, and I don't want the prosecutors deciding what is relevant to my case. I don't want them deciding, you know, what's important to me. They don't know my case. And I should get all of the evidence, and then I should marshal the evidence, and I should be able to present my case the way it best represents, I can best represent my client. We are in a position when we have these exonerations to analyze the causes of the wrongful convictions to begin with, and not turning over all the evidence. You know, in hindsight, we've studied these cases, is a major cause of these wrongful convictions and a major cause of these innocent people being wrongfully convicted and imprisoned for crimes they didn't do. In the Michael Morton case, you know, it was a well-publicized, tragic wrongful conviction, and they, you know, the people studied that case. There was a court of inquiry, an involved court of inquiry with high-powered lawyers conducting it. And one of the things we do is we try to identify the causes and rectify the causes of these wrongful convictions. That was done in the Michael Morton case, and they came up with the Michael Morton Act. And to roll back the Michael Morton Act, which is what this 3330 does, is going to cause more people, more innocent Texans, to be wrongfully convicted and sent to prison for crimes they did not commit.
Okay, thank you.
We think that's a problem, and for that reason, we are against it.
Okay. Any questions for Mr. Ware? Thank you for being here.
You're welcome.
Chair calls Bay Scoggin. Have you registered as Bay Scoggin with the Innocence Project against the bill, correct?
That's correct. Thank you, Chair. Appreciate the opportunity to be here. I just wanted to, I'll be as brief as possible and not try and repeat what's already been very thoroughly discussed. I wanted to say thank you to the members of the committee for such an engaging discussion and for being here so late. Also just have to absolutely thank the exonerees and their families for being here today. They've been here all day just for their 2 minutes to come and tell their stories, which is always, I think, a challenge. And that, I hope, speaks to how important it is that this bill stay where it currently is. The last thing, I have two final pieces to add. The one is I have also read the Heath decision, and based on my reading, there is nowhere that the Texas Criminal Court of Appeals or any appellate court encourages the legislature to take that action. It says very clearly that if the legislature desires that change, it certainly can make that change, but in no place does that encouragement gets made. And the second piece is, the only piece of the bill that I don't think that has been thoroughly discussed is the addition of a specificity requirement for discovery. As defense attorneys, or even in post-conviction, we don't always know what exactly we are looking for because we don't have a theory of the case. So to create a requirement for specificity before we know what we're looking for is hiding the needle in the haystack for us to ask for the right needle and make sure it's the right color too. So for that reason, I will stop and thank you again for your deep consideration of this bill. Thank you.
Thank you. Any questions? Ms. Jones?
So I'm glad you brought that up because I was going to bring that up. You actually, as a defense lawyer, if you'd agree with me, we don't always know what's relevant. We might not even know what's important. Like we will have a bunch of evidence and we don't know why it's important because we hadn't been able to investigate everything. And then after we investigate further, we'll be like, oh, no wonder this either makes my case or it doesn't. Sometimes when we get the evidence, I have to go to my client and be like, dude, you maybe need to let me work a deal out for you. So it may actually encourage pleas, especially when your clients are lying to you, right? And then you're like, no, sir, that's not going to happen.
Right.
So thank you for bringing that up. And I'll also say that why shouldn't the defense get the evidence the state has? And I mean, why do they get to know stuff and we don't? At the end of the day, you give us both the same evidence, state, you better figure out how to convict somebody beyond a reasonable doubt. And hiding the ball isn't one of them. Why are you afraid for us to have the information that you have, which is probably why Michael Morton, that act happened, and it's probably why Governor Rick Perry, who's a Republican, newsflash, I'm not, said what he said, because it's a common sense, bipartisan bill that erred on the side of protecting the Constitution and understanding that the government has the burden of proving it beyond a reasonable doubt. So I thank you for coming, and I also, too, want to thank the exonerees for coming, because one person that's wrongfully convicted is too many.
Yes, ma'am.
Absolutely. Ms. Rodriguez-Ramos.
Thank you, Mr. Chair. The specificity you're talking about is line 16 on page 1, where the state, they have to receive a timely and specific written request from the defendant on any. Okay.
Yes, ma'am.
Thank you. I think that is cause for concern as well. Thank you.
you.
Appreciate it.
Any other questions? Thank you for being here.
Thank you,
Mr.
Chair.
Scoggie. Appreciate it. Chair calls Joe Patton. Mr. Patton, you've registered as Joe Patton on behalf of the Dallas County Public Defender's Office and yourself against the bill, correct?
Yes.
Thank you, sir.
Thank you for your time this evening. I'm going to defer to the wisdom of my colleagues, my brothers and sisters who are opposed to this. And I appreciate the questioning from the committee, especially pointing out the concerns about potentially hiding evidence under the guise of irrelevancy and the consequences of that. But I wanted to focus on, as a trial attorney in Dallas, some of the other collateral consequences of this. The language, and as you just pointed out, that's been inserted in this bill means that as a trial attorney, we are going to have to go to war on every single piece of evidence that the state gets caught on, whether, if it gets past the relevancy part, we have to ask a judge or litigate whether the request was specific enough, whether it was prompt enough, which goes to one of the points you raised earlier about the timeliness of the disclosure of all the documents you got. Under this current bill, the prosecutors can now say, well, perhaps they should have known about it before. There's other evidence that was there to indicate this is there. Their request for additional discovery was not prompt, even though the disclosure was late. Again, the question of relevancy, the prosecutor's interpretation of that versus the courts and the defense attorneys. What is going to be a fact of consequence in a case? What is the purpose of this action? What is unduly broad? What is unduly burdensome? What is a privacy interest? What is a security interest? What is reasonably necessary? What is actual prejudice? Are we going to start redefining what a party means in criminal justice and trial? The issues regarding remedial alternatives, whether they've been exhausted. And finally, the inclusion of the language knowingly in regards to whether a prosecutor acted knowingly or not provides so much protection for the prosecutors in situations where they have failed to disclose evidence. And I would urge you, and I request respectfully, that you reject HB 3330.
Thank you, Ms. Patton. Any questions? Thank you for being here. Chair calls Richard Miles. And your affirmation shows you as Richard Miles and the founder, CEO of an organization, but it doesn't say which organization.
Miles of Freedom, that's my nonprofit organization.
Okay, so are you just testifying
Testifying
on behalf of yourself?
Yes, sir.
Okay, that'll be fine, and you're against the bill, correct?
Yes, sir.
Thank you, sir.
All right, to this esteemed panel, I would like to extend my gratitude for the opportunity to share a portion of my story as well as my stance in opposition to HB 3330. My name is Richard Miles, and I'm a husband, I'm a father, and I'm the founder and president of Miles of Freedom, but I'm also a Dallas exoneree. May 15, 1994, at the age of 19, I was wrongfully arrested. 17 months later, August of 1995, falsely convicted of murder and attempted murder. I was given a total of 60 years in the Texas Department of Criminal Justice. After my direct appeal was denied in 2000, the filing of my writ of habeas corpus fell on the shoulders of myself and my father. With the assistance of my dad, who passed 6 months before my release, we obtained my police records, in which, through a Freedom of Information Act, because we could not afford my transcripts. We found nothing of importance in those police records, but I filed my writ anyway, and it was denied in 2002. In 2007, Centurion Innocence Organization accepted my case, purchased and sent my transcripts and police records. It was within these police records purchased by Centurion that we found 3 pieces of exculpatory evidence in the police files recorded before my trial but never introduced as evidence, and I add was not disclosed with our Freedom of Information requests. This apparent Brady violation began the ball that would ultimately provide not only my release but also my freedom. HB 3330 seeks to roll back the structural framework of the Michael Morton Act, which could inevitably impede upon the pursuit of justice. I lost 15 years of my life. I will never know why the evidence wasn't submitted or if prosecutors felt the evidence was relevant but not material. But I can share my story and ensure those convicted or guilty victims receive due justice, and no innocent person is incarcerated in prison.
Thank you very much, Mr. Miles. We certainly appreciate your story.
Thank you.
And I think Ms. Jones has a question for you.
Yes, so first of all, I want to thank you for persevering, and I'm thankful that you got somebody who believed in you and actually paid for what you couldn't afford to pay.
Yes, sir.
I just want, if you can, in like a minute or less, what did you lose in the 15 years that you were locked up?
What did I lose in the 15 years outside of my physical family members? I lost who I was. I oftentimes say May 15, 1994, Richard Ray Miles Jr. died. I was going to Skyline High School, headed to TSTC to study engineering. That ended May 15th. Who I am today is subsequent of what I've been through.
Thank you.
And I will say this, I think I've visited with you before. I've met with a number of exonerees. The thing that amazes me more than anything is the lack of bitterness that's there.
Yes, sir.
I'd probably be pretty bitter over the circumstance, but it's not only a lack of bitterness, but the kind of the drive to try to help others that were in your position. So
Yes,
we
sir.
all appreciate that, what you do.
Thank you.
Anything
Thank you.
else, members? Thank you for being here,
Appreciate you.
Mr. Miles. The chair calls Sean Dick. And Mr. Dick, I show you on your affirmation as representing the Williamson County District Attorney and yourself. You're the District Attorney in Williamson County, correct?
I am, Mr. Chair.
And you're for the bill?
I am.
Okay, thank you.
My name is Sean Dick, and I'm the District Attorney of Williamson County. My practice has been, I started off in the Harris County DA's office as an assistant DA. I worked there about 5 years. I moved to Williamson County as an assistant DA for roughly 4 to 5 years. And then I went into private practice and fought in Williamson County against a closed file system. And I was a defense lawyer for 11 years before becoming the DA. I'm mindful that I'm the Williamson County DA coming here to talk about a modification to the Michael Morton Act. I'm also mindful that every other DA in Williamson County since the 80s has gone to jail. I joke that I'm in the off cycle, but it's not really that funny, right? Because we have had prosecutors do some bad things. And so I embrace the Michael Morton Act. I think that it was a good change. It was a good paradigm shift. But we're not talking about the 80s and 90s anymore. You heard Mr. Udishin tell you that this isn't the issue that it was before. But what didn't happen and the problem I'm trying to solve is twofold. First of all, something that has changed in the last 10 years is the volume of information. So Representative Little, when I hear you talk about your civil case and getting, or your criminal case and getting 400,000 documents, that's what our prosecutors are starting to face. The difference is my prosecutors have 500 cases a year that they're working on, 500 felonies a year. And now, just to give you an example, this is just the log, the Michael Morton log for one of our homicides. It contains 11,500 pieces of digital evidence. Might be a 3-hour video, might be a 20-minute audio, might be a 50-page offense report, but 11,500 pieces of evidence that I want to give the defense. So this is something we feel very strongly about, and we need a way to make sure we're never going to fight over the 11,500 pieces. Usually the fight is over the things that aren't contained here. My second issue, and I really want to focus the committee on A2, O, P, and Q. Those are the problems that really need to be addressed. And one of the reasons is we had a former elected judge in our county that comes back and visits from time to time. And recently, we had a child abuse case where the prosecutor discovered that the police had actually taken the defendant's phone at the time of the offense, but no one had ever done a search warrant. So as the case got set for trial and she's got all this evidence to look through, she realizes we need to do a search warrant. So it's the defendant's phone. He knows there's a search warrant being done. And about a month out of trial, the police found child porn on the phone. And not only did they find child porn, they actually found pictures of the children that were victims in our abuse case. And the judge, basically, based on the Heath decision, suppressed it. Not only did he suppress that inculpatory evidence, but he also granted a continuance. So instead of granting a continuance, giving everyone the opportunity to review the evidence, the judge used the Heath decision as a basis to suppress inculpatory evidence in a child abuse case. So that's what I'm thankful to Representative Cook for filing this bill, because those are the kinds of issues we're trying to address.
Okay, we appreciate your being here. Ms. Jones, you have a question?
I'm trying to figure out why you chose to be the elected DA, and kudos to you, and I hope you don't go to jail like those before you.
I ask myself that same question
but
often.
I can't see bending the Constitution because you have that for one homicide.
Right.
I mean, it's like, not at all trying to be disrespectful. It's like, oh, please feel sorry for us because there's a whole bunch of stuff and we may not have enough money. And so you need to just give us, please let us admit it.
Sure.
Right. So
Sure.
to he who has all the power to lock everybody up
Sure.
comes great obligations and responsibilities. And one of those is I don't care how many documents you have, even if they're 400,000, you need to do it.
Correct. And
Right?
we
So
have no qualms doing it. The issue becomes, my prosecutors often say their job is really just a discovery clerk. They're not lawyers anymore. They can't really go to trial because they have to read through all of this evidence themselves. They have to figure out, is there anything else out there? And like I said, we don't have fights over what we actually have and give over, and we give over everything we can possibly get our hands on. The fight is usually over something like, Montgomery County DA Liggins said, it's, we want every police report that's ever been filed by this Texas Ranger. We want every, medical report that this doctor's ever reviewed. So at some point, there has to be a way to have a balancing test in court, and you have to have the judge hear both sides, and the judge could say the same thing you're saying, which is, I don't care, you're the state, go get it. And that's fine. But right now, there's no provision, there's no findings a judge has to make, and we can't appeal it, we can't have any discussion. Like in the suppression issue, all this is doing is saying the judge has to make some findings based on some parameters that you all set. That's it. And if we lost the evidence because it took us too long to find the cell phone, then we lost it. But right now, we don't have a remedy as the state because there's no process or procedure written into the statute.
Actually, I would respectfully disagree. You actually do have a remedy. Your DA could have looked at the evidence and looked in the phone. So the fact that for whatever reason.
Well, we can't look in it without the search warrant, so the search
right,
warrant had
but
to be done.
if your DA knows, because you know what's in evidence.
Right.
If your DA knows that there's a phone in evidence, your DA should have looked. Your DA should have got a search warrant, and they should have looked in it. So, I mean, I'm just.
And this bill doesn't stop that, because if you were the judge, you could still suppress it. You just have to make the findings that are in the statute. You could say that it was highly prejudicial to the defendant.
But why?
And therefore.
We have something that's worked. The Michael Morton Act has shown that there's less wrongful convictions. And just because now the Michael Morton Act requires y'all to actually do your job, now it's like, oh, it's really hard. And I feel sorry for the Constitution being trampled on and set back. And I feel sorry for people who are entitled to constitutional rights to be made less important because it's more difficult for the state. And I'm just going to have to respectfully.
Yeah. I don't think the first part of the bill is really the crux of it for us. I think it's really those last sections that are the important part. And I understand we have good colleagues out here that have a differing opinion.
Okay. Any other questions, members?
I would just ask you to expand on those a little bit, if you could. Thank you, Mr. Chairman.
Sorry, if you could.
Yeah, as far as you pointed out a couple specific provisions in the bill, and I believe you said paragraph O and P, is that right?
Yes. So A2 provides for a hearing where we could say, the defense has asked us to go get additional information, that we don't have it in our file, the police departments don't have it, but the defense has asked us to go get additional information, and we can go to the judge and say, Judge, they're asking us to get this. Is this something that the court's going to require us to go get because of the following factors? And so that's A2, and I have it on page 2. And then provisions O, P, and Q on page 4 going to page 5. That basically, O is really hard to contest because it's just asking for a discovery hearing for everybody to talk and get together in a court and make sure everybody has everything. And what P says is a judge can grant a lot of things. I mean, they could say, we're going to give a continuance and we're going to let the defendant out on a bond that they can make because you gave us this evidence too late. They could grant protective orders. But before a judge could suppress inculpatory evidence, the judge would have to make a finding under Q that either we knowingly withheld this information or the violation caused actual prejudice to a party other than remedial alternatives have been, and other remedial alternatives have been exhausted or would not suffice to cure the prejudice. So that's just some standards that a judge looks at. They make a ruling, and this is what judges are trained to do. Judges are asking for this kind of guidance because they really don't know right now how to handle violations of the Michael Morton Act. We've had it on the opposite side. We've had defense lawyers that have actually provided copies of material that aren't authorized under the statute, and they've given it to witnesses, copies of it. What's the remedy for that? We're not coming in here asking to sanction defense lawyers and punish defense lawyers. We're just asking to provide some fairness to the state in this process and allow a judge to make some determinations throughout this process. I hope that answered your question.
Yeah, I think so. I mean, and specifically talking about OP and Q, do you feel like those, if those provisions are enacted, that those trample on the Michael Morton Act? Or?
I do not in the least.
Okay, thank you.
Any other questions? Okay, thank you for being here,
Thank you.
Mr. Dick. The chair calls David Gonzalez. And Mr. Gonzalez, your affirmation shows that you're David Gonzalez, testifying on behalf of the Texas Criminal Defense Lawyers Association and yourself, and you're against the bill, correct?
Yes, sir. Representative Cook, if I can pick up with your conversation about Newell and what the remedy is. For those that are civil lawyers, I think Newell talks a lot about what it means to practice in civil court, in his opinion, and I'll read portions of it because I think it wasn't a big deal for those that practice civil law. I don't think Heath had that opinion, because here's what he writes. Notably, under the civil rules, exclusion of evidence that was not timely disclosed is the default. And he goes through spoliation and all the kind of remedies that typically happens, and it doesn't require bad faith. He just says that's what we do in the civil rules. Even inadvertent failures to disclose evidence results in these sanctions. And he says here, look, the trial court has broad discretion, and we don't think that what the trial court did is any different than what we see every day in the civil capacity. And if you look at the Michael Morton Act, a lot of it was kind of based on the 194 automatic disclosures that we stole from civil lawyers. Here are just the things that we're going to ask you for. You don't have to have specificity. Everybody just exchanges these at the beginning. And it was this idea that no longer do lawyers have to go through 40,000 pages. It's just a default to production. And then the defense has to go through it. Finally, I'll just comment related to the OP and Q. I think what you're hearing a lot of complaints are really related to A2 to begin with, which is this new carve-out that you don't have anywhere in civil rules. In A2, that basically says if someone says, I've got a privacy interest of any victim or witness, like I don't want my statement to be disclosed. God, in civil cases, you can't stop that disclosure, but now I don't have to produce the things that I don't want to produce if it says that. As to the other things, I think a lot of that the trial court has discretion on to begin with, but that's what I wanted to address just related to how I read Justice Newell or Judge Newell's opinion. Thank you, sir.
Okay, thank you, Mr. Gonzalez. Any questions, members? Thank you for being here. Chair calls Brian Middleton. And Mr. Middleton, welcome. Your affirmation shows you Brian Middleton, District Attorney for Fort Bend County.
Yeah, that is correct, sir.
Okay. And you're neutral on the bill.
I am.
Okay.
You know, this morning I think I had real strong opinion, and I admit I'm a bit exhausted right now. But just 6 years ago, I was a defense attorney, and the importance and the value of the Michael Morton Act is still relevant to me. I practiced law before the Michael Morton Act and after the Michael Morton Act, so I know the difference that it made in our practice. And to be clear, no matter what this committee does with this bill or the legislature does with it, it's not going to change how we practice law in Fort Bend County at the DA's office. The expectation is to win or lose on full disclosure. We have pre-indictment discovery, so this is not in any way going to change how we do business, and I think that's what justice requires. And you're right, Representative Jones, you know, we have the Constitution, and I don't think even passing this is going to change the Constitution. So our obligations under the Constitution will remain. So listening, I've learned a lot. I even had some of my colleagues call after my testimony before the Senate, and we discussed some things, and there are some issues with A1 and A2, which is why I'm neutral on the bill. But I agree with Sean Dick that there are some guardrails in here, particularly O, P, and Q, which I think are fair. What we're not discussing is how this shows up. The way this is going to show up in court, there's going to be a motion and there's going to be a claim that you, prosecutor, failed to turn over some evidence. And so when I read the Heath opinion, it gave me heartburn because I accept the responsibility as the state that in its broadest definition as Heath claimed. But I have supervision over prosecutors, staff, and investigators. I don't have supervision over police agencies and other agencies. So when they certify to our office that they've turned over everything, I don't have a means of verifying that. And so to think that myself or one of my prosecutors could be in a court found to have failed to turn over evidence without some finding that there was some bad faith is problematic. These accusations, I mean, they're traumatic for some prosecutors, but they can follow them in their careers, and that could lead to grievances. So I support the bill as it relates to OP and Q. As to A1, I think some of the concern is what we all know is what some judges may do with this type of language, and that's bad faith, either by the judges or the prosecutors. So
Okay.
I think it's a good start, and I think maybe we should look at some revisions to A1 and A2.
Okay. Any questions, members? Thank you for being here.
Thank you.
Milton. We have Jeremy Kaplan-Lyman. Jeremy Kaplan-Lyman. We'll show Jeremy Kaplan-Lyman as registering for himself, testifying for himself, registered against the bill. C.J. Grisham, is Mr. Grisham still here? We'll show C.J. Grisham on behalf of himself, registered neutral on the bill. We have the chair calls John Rayleigh. Thank you, Mr. Rayleigh.
Yes, sir.
And your affirmation is that you are John Rayleigh testifying on behalf of yourself, and you were the Mr. Morton's pro bono attorney for his exoneration, I understand, and you're against the bill.
I am, sir.
Okay, thank you, sir.
I'm John Rayleigh. I was Michael Morton's pro bono exoneration counsel for 7 years. Michael's wife, Christine, was murdered by a burglar when he was at work. For 7 years, we fought against the then DA of Williamson County to obtain DNA testing on a bloody bandana found near the murder scene. During that time, we sent a FOIA request to the DA to obtain the file. They objected, even though the murder was 23 years ago, saying it was an ongoing investigation and they wouldn't have to turn it over. Then Attorney General Greg Abbott disagreed with them and ordered it turned over. We found evidence concealed from the defense at the time of trial, including an eyewitness account of the murderer being someone other than the accused, and sightings of a stranger in a green van parked behind the Morton house that we now know was driven by the murderer. After our 7-year fight, the DNA results exonerated Michael Morton and led to a positive identification of his wife's murderer, a man named Mark Allen Norwood, who had a 30-year record of felonies in 3 states. Michael's request when he was freed was we try to find a way to keep this from happening to other innocent people. So we asked some great minds to get involved, and the legislation was drafted. The key is that the prosecutor cannot be the gatekeeper of evidence. An honest prosecutor, like my late father and like my brother, like so many prosecutors we know, will follow the law, and that's a good thing. But a morally weak prosecutor, like the then prosecutor of Williamson County, may yield to the temptation to conceal evidence, which is what happened. And the defense lawyer, lacking psychic power, would have no way of knowing whether or not the evidence was concealed prior to the Michael Morton Act. And you see what happened, and I'll close with this and answer any questions. If you if you convict an innocent man, you're letting the murderer go free to kill again, which is exactly what happened in the Michael Morton case. They concealed the evidence of his innocence. They let Mark Allen Norwood go free. And within a couple of years, right here in Austin, Texas, he killed another young mother in exactly the same way he killed Christine Morton. So that's why this is so serious. I urge you, in the name of justice, which I believe God cares a great deal about, to oppose changing the Michael Morton Act. Now, I would answer any questions if you have any.
Thank you, Mr. Raley. Any questions, members? Ms. Jones?
Just one thing. I want to thank you for representing Michael Morton for 7 years for free.
Yes, ma'am.
Not a lot of people would do that. But I also can tell that you have a love for the Constitution.
Yes, ma'am, I do.
And here in Texas, we believe in law and order and the Constitution.
And you remember, Representative Jones, that Alfred Dwayne Brown spent 12 years on death row coming from Harris County. He's now been declared actually innocent. The prosecutor in that case concealed evidence as well. So this is a very, very serious matter, and I know that you're taking it seriously.
And you heard, have you looked at, you've looked at HB 3330, I'm sorry.
I have.
So you've heard comments by some of the DAs saying, well, okay, we know that A1 and A2 might have problems, but is it OP?
They seem to be skipping over the parts that allow the prosecutors to be the gatekeepers again, which was the whole idea the Michael Morton Act was designed to solve.
Right,
They
but-
want to go past that to the end.
So-
I understand why they want to do that, but I hope that the committee does it.
So while they've admitted, for the most part, that A1 and A2 have issues, right? They've said, yeah, but O, P, and Q, they're really not bad. It gives the courts like something. What do you have to say to that?
With your permission, Representative Jones, I would
Absolutely.
like that question to be answered by a criminal defense lawyer. My criminal work is limited to pro bono exoneration of wrongfully convicted people. So I would be concerned of any modifications to the Michael Morton Act. I'll tell you, if you would let me answer the question fully, Representative Little, the whole idea came about, and those who oppose this thing blame me, because Michael said, what can we do to keep this from happening to other innocent people? And I said, I'm a civil litigator. I know that if it just involves money, in discovery, I can find the other side's documents. I don't understand why, if it involves a man's or woman's life or liberty, that isn't more important, not less important. And there being no answer to that question, I was smart enough to know I need to get really smart people involved, and the Innocence Project of New York and all these great lawyers all contributed, and it came about, and it's used almost every day in 254 counties in Texas. And I don't think we can calculate how many innocent people have been prevented from being wrongfully convicted because of this bill. So I urge you not to make changes to it.
Mr. Little has a question.
Yes.
John, I just want to say thank you for coming. Thank you for all you've done. You and I had a case together years ago. I can't put my finger on it, but it's good to see you
Yes.
again.
Good to see you.
Yeah, thanks. Thanks for being here.
Thank you.
Thanks. Anything else, members? We do appreciate
Thank
you
you.
being here. The chair calls Sam Bassett. And Mr. Bassett, we have you registered as Sam Bassett on behalf of the Texas Criminal Defense Lawyers Association and self against House Bill 3330, correct?
Yes. There are so many smart lawyers that have taken apart this bill, I don't dare tread into that territory. I'm a criminal defense lawyer. I've been practicing for 38 years. And tired. In 1987, I stood close by Michael when he was found guilty. I was a third-year law student working on the trial team. I saw him almost faint. 25 years later, I helped Deborah Baker's family, the woman who was murdered by Mark Norwood. I helped her children achieve justice by representing them on behalf as a victim advocate. Michael's case and Deborah's situation is not the only one. I'm emotional about this because my career, my legal career, has eclipsed this issue from the start of Michael Morton being convicted to today. And I got to serve on the Timothy Cole Commission with Representative Smithy, and I got to hear a lot of stories. And I think what this comes down to is if you take teeth out of this bill, it de-incentivizes the fringe law enforcement agencies and the fringe DAs, not the ones who are here today. People here today are fine people. But the rogue sheriff deputy who decides not to turn over something to a DA's office because he's certain he got the right guy. And one thing I remember about the Michael Morton trial and the guys that I worked for is we kept thinking there's something we don't know. We don't know what we don't know. What is it? We couldn't find out. And we didn't find out for 25 years. And that's the gist of the Michael Morton Act, is as a defense attorney, you don't know what you don't know. And I'm sorry for being emotional today, but that's what I think about this situation, and that's why I think this bill should not be modified.
Mr. Bassett, thank you. Good to see you again. Any
Thank you.
questions for Mr. Bassett?
Yeah.
Yes, Mr. Cook?
Yeah, the last statement you said, that's why you think this bill should not be modified. Are you talking about this bill, or are you talking about the Michael Morton Act?
I'm talking about the Michael Morton Act. Yes.
I figured you were.
Thank you very much for clarifying that.
But, so my next question is do you agree that paragraphs O, P, and Q do not make any change to the Michael Morton Act?
I think they do.
Well, tell me how, because I disagree.
I think the judge, it inserts a bad faith requirement for prosecutors withholding evidence. I think it also eliminates a judge's discretion on how to handle evidence that has been failed to have been turned over. In Heath, there was no bad faith. The judge didn't find there was bad faith.
I'm not talking about Heath. I'm just asking, with regard to my bill, paragraphs O, P, and Q, I'm asking how they make changes to the Michael Morton Act, because I don't believe they do.
It limits a judge's ability to suppress.
Where it says where it says a judge may, a court acting under subsection may suppress, that's limiting? If
He
it
may
said, if it said,
suppress only if the court finds that. I think that is a limitation on the judge.
okay. I mean, do you think do you think that is a change? I'm just asking if you know of any changes to the Michael Morton Act. That's my specific question. Like with regard to paragraphs O, P, and Q.
I think that's a change.
Okay. And you think that's in paragraph Q?
I know it says may suppress, but it also says only if the court finds, one, the non-complying party knowingly withheld the required discovery, or the violation caused actual prejudice to a party. I think that is a limitation on the judge's discretion that's not currently in the Michael Morton Act.
Okay, so that's what I'm getting to.
Yes.
You do believe that that's a change to the Michael
Yes.
Morton? Okay. Thank you. Appreciate your testimony.
Thank you. Anything else for Ms.
Yes, ma'am.
Jones?
Mr. Bassett, thank you. And I think that your tears are authentic, and if you can't cry over this, then what can you cry over? But, so here's a question, and it's a leading question on purpose. Would you agree that sections O, P, and Q would materially change the judge's discretion, which is a change to the Michael Morton Act?
Yes.
Thank you.
Okay, any others, members? Okay, thank you for being here, Mr. Bassett. We appreciate that. We have, the chair calls Jeremy Rosenthal. Mr. Rosenthal, as with all the other witnesses, we appreciate you hanging with us
Thank
this
you.
long. And you're registered as Jeremy Rosenthal on behalf of yourself against the bill, correct?
That's right. TCDLA won't claim me, but that's okay. I love them just the same. My name is Jeremy Rosenthal. I'm a board-certified criminal lawyer. I practice in McKinney. Just to kind of clean up a lot of stuff, I mean, we've been kicking this thing around now for a few hours. Just kind of let me talk to you all about the life cycle of a case, because we've been hearing a lot about capital cases, but certainly this impacts a lot of non-capital cases, a lot of sex abuse cases, a lot of drug cases, cases across the board, right? The meat and potatoes of the criminal practice. So when you get a criminal case, let's talk about the discovery and how it works and the information systems and how they work. You have a baseline of zero evidence, right? And then you have the incident that happens, and then you've got body cameras, and you've got witness statements, you've got biological tests, you've got all these things, you've got interviews. So your evidence goes from here to up here. And then we get a true bill a lot of times, and then our line flattens, right? We're not doing a lot of discovery work. Prosecutors are not doing a lot of work in this instance. They're exchanging evidence with the defense, or they're giving it over, they're complying and all these things. But there's not a lot of investigation that happens. And with apologies to the Williamson County District Attorney, he is absolutely correct, and I am sorry that being a prosecutor in the 21st century is about disclosure. But we've also heard that it's working. We've heard that it's working extremely well. When you look at the major famous exonerations in this state, I'll tell you what they all have in common. They're all before Michael Morton. So we know that what we're doing is working, absolutely. What happens in any criminal case is that when the case gets set for trial, because I'm looking at the case and I think I can win it, the prosecutor thinks they can win it, maybe it's a punishment issue, but then what happens is we go from this flat line of discovery to we're 3 weeks away from trial, we're 2 weeks away from trial, we're 1 week away from trial, and we're learning more and more information about it because the DA's office is putting people in the field. They're putting their investigators back in the field. The defense is doing the same thing. We're interviewing people. All lawyers are putting out the hottest fires. That's what we do. And so the prosecutors are doing that. That's why we get so much information in the last 24 hours or 48 hours.
Could you kind of wrap up?
Oh, sir. Well, I think it's important because I am going to address P and Q and all that. This delta of new information that we always get at the very end, okay, it consists of exculpatory material, it consists of inculpatory material, mitigation, it consists of everything in the above. And ultimately, you know who's the first off, what we have to do is we have to flatten the discovery curve so prosecutors are getting this done earlier in the case cycle. And the second thing that we have to do is we have to trust our district judges to make these decisions, to hold, and I'll tell you how we solve this. It's real simple. You go to John Roach's court in McKinney, you're ready. You're ready from day one.
Okay, let me see if there's any questions. Any questions, members?
Yes.
Yes, Mr. Little.
Jeremy, you and I have been friends a long time. I just want to thank you for the sacrifice of traveling here. I know this is very important to you, so thank you for your time.
Yes, thank you.
Anything else? Okay, thank you, Mr. Rosenthal.
Thank you. Oh,
Okay.
yes.
Okay, Mr. Moody, I'm sorry.
You said you wanted to drill down on maybe a couple of the sections.
Right.
So I don't want to deprive you of that opportunity.
Thank you. Okay.
I don't know where,
So when we talk about Q, it does change. The judge has to make a finding that one of two things have happened. There's this issue with knowingly withholding evidence. And Representative Moody, I have never understood this. I was a baby prosecutor one time, and anytime somebody said you didn't give me something, oh my gosh, you're calling me names. Oh my gosh, we're going to go outside and fight. Oh my gosh, it's all about me. It's not about me. It's about the jury. Jury doesn't get to see that. And whether a prosecutor has done something on purpose or whether they are, pardon me saying, whether they're lazy and they don't get it done on time, it's about the truth and it's about the jury and what the jury sees. So showing some type of animus or that they purposefully cheated is pointless in my mind. The second part, that's an impossible standard. I've never proven that to any judge anywhere. That they violated, caused actual prejudice to a party other than remedial alternatives. Well, we'll know if it's a guilty verdict, right? If it's caused actual prejudice. That's a really unworkable standard. So I think that those parts of the bill are very problematic.
Well, and I think, and I'll end here, but I think the point you raise is very salient, is nefarious or not, the net effect to the accused is the same.
I'm building a rocket ship when I prepare for trial. If I don't have the right parts, it doesn't fly. It doesn't matter if I didn't get it on purpose, and it doesn't matter if it was never in the box to begin with.
Well, I'll be very clear. I've been in those same shoes as a baby prosecutor, and you're trying to do the right thing.
They are.
And you are trying to make sure that it's all present and everything has come forward. Your case is, I mean, quite honestly, your case is always better when you proffer everything you got, warts and all.
In fact, if you're a prosecutor that's not addressing the warts of your case, then you're not really preparing for trial.
That's right.
And so, you need to protect against both. There are the heightened examples of the Michael Morton case where you have a nefarious purpose, and some others that we've talked about. And then you have some where it's like, this just got missed. But the net effect to the accused and their rights is the same, no matter if there was animus or not. And so I think that's what we're trying to drill down to.
That's right.
And so I certainly appreciate your patience in waiting here with us and testifying tonight.
And
Thank you.
to her point, to Representative Jones' point, you disclose everything, you might just convince me to plead guilty, right? And if we're going to go and fist fight in front of the judge about what's reasonable and not, to the prosecutors in the room, be careful what you wish for. That sounds like a lot of litigation to me. So thank you. Oh,
Ms.
yes.
Jones.
And I think you bring up a salient point with the knowing, but I not too long ago had a case where there was a ton of evidence. There were probably 60 body dash cams, which meant I had to go through that. And when I was getting to it, I said to the state, hey, I'm looking at these body cams, from all the different officers that showed up, from all the different perspectives, and there's nothing that identifies my client, like nothing. And I said, have you looked? Because if we go to trial on this, I'm probably gonna whoop you. And the prosecutor, we literally got resets for the prosecutor to evaluate the cases. So that happens sometimes, right? And the judge kept giving grace to the prosecution. And we had like 3 resets, which each reset was over 30 days. Meanwhile, back at the ranch, my client is screaming bloody murder. You're not working for me. You should have gotten this dismissed. Those tapes you showed me don't show anything. Why can't you get this dismissed? At the end of the day, like 6 months later, the case finally was dismissed. When if the prosecution, to your point, had just looked at it earlier, the case would have been over. So, and I don't even know if, like you said, there are lazy prosecutors. Trust me, I know that. But there are prosecutors that literally wait until a case is set for trial. They wait for 2 weeks before a separate trial, and then they look at the evidence. And that happens. And I think that if that happens, then the prosecutor literally shouldn't get any grace. They shouldn't get grace. I know that trials in Harris County are 2-3 years away, at least. When if they would just look through the evidence, cases could be resolved very quickly. And it would save counties money, it would save people's lives, and it would also get rid of a lot of the work that they have.
And I'll end on this. The solution is a strong district judge with full discretion to take everybody in their courtroom, put them on the spot, and ask them hard questions and do what they need to do to move their docket. Thank you.
Thank you, Mr. Rosenthal. Chair calls Nicole DeBoard Hoagland. Okay.
That's why I leave the other one in there. So my married name, for those of you who don't know me, is Hotch Globe, and there's a lot of letters in there.
Okay, so you're Nicole DeBoert Hotglobe. You've registered on behalf of yourself against the bill, correct?
That is correct.
Thank you.
And by way of introduction, I'm a former or past president of the Harris County Criminal Lawyers Association. I'm a former prosecutor from Harris County. I prosecuted with many of the district attorneys who you've seen testify here today, and Joan Huffman. Back in many, many moons ago, I don't have the same gray hairs that Prosecutor Ligon has, mainly thanks to Ms. Clairol, but I want to take some time to highlight some things that cause me a great deal of concern. I'm here in opposition to 3330, strong opposition. So in such strong opposition that I had a trial setting this morning, wrapped up in court, and got myself to Austin as fast as I could so that I could be here to answer any questions that you might have today. Representative Cook, you had some questions that I thought merited me jumping to the end to address, questions that I think are important concerning certain sections of the bill. I would argue that they do significantly change the Michael Morton Act. And specifically, I would say subsection O puts strict time limits on when the defense can raise an issue, which really kind of begs a question that John Raley raised in his emotional, and I have had a chance to meet with Michael Morton, and the emotion is, and that Sam Bassett came up here and gave to you. I mean, this, what you didn't hear, but I think you know, just to remind you, is that when somebody is wrongly convicted, aside from the people who suffer because a murderer runs free and does it again, Michael Morton had a 3-year-old baby when he went to prison for 25 years for something he did not do. That child grew up for a majority of his life believing that his father killed his mother and lost contact with him. That is a loss that is indescribable. I see I'm almost out of time. It limits the judge's ability, which the judge already has currently under Michael Morton and Heath, to choose correct sanctions. And I see my time is up. If I could finish my thoughts with your permission.
Finish your thoughts
about what should be done. Heath, as we've already heard, a very conservative judge weighed very fact-specific information and determined that that particular evidence should be excluded. And then what happened is it went all the way up to the highest court, our Supreme Court of Criminal Law in Texas, and that court agreed with the judge's discretion. It was vetted, and it was vetted again, and it was vetted again. And now the case can still be tried, and it will be tried. So this bill does change that kind of discretion. It eliminates what is a fact-specific, flexible standard, allowing the people in the room to evaluate the facts and what are the appropriate consequences. It takes that away. And to me, that's a tragedy.
Any questions for? Yes.
So I guess I just want to flip in for a moment and talk about the victim, because I mean, there's no chance, that I would speak against the Michael Morton Act and what has happened to Mr. Morton. On behalf of the state of Texas, I apologize if that happened, and it's very disturbing. But just I want to ask a question: how you would, if you have an opinion for the legislature, let's assume that the defense counsel does have some type of evidence that the prosecutor truly does not know about, and that the defense just waits until the time of trial, and that basically throws out a case. Let's pick a gruesome case. Unfortunately we have lots of examples from Harris County specifically, or wherever. But if you just pick one of those types of cases, and based on a suppression, and clearly the defense is not being prejudiced in that situation. In fact, I think the defense counsel is being strategic, and obviously, I'm sure y'all do everything you can possibly do to represent your client zealously. But if that results in a case being thrown out for the victim, from the victim's perspective, is there any type of suggestions that you would have, whether it's for this bill or future legislation, or just in general?
I very much appreciate the question, Representative Cook. And I will say, one of the things that really significantly impacted the way I practice law I was a prosecutor for almost a decade under Johnny Holmes back in Harris County. Very different time, very different administration. And I thought that I knew things. I really did. I believed in, we all marched down there to the courthouse together, thinking we were doing what was right. And believed in it to our core. And we had a boss back then who would say, fire us if we proceeded with evidence that was illegitimate. You got a lab report back after you pled somebody, for example, on, what we used to call turkey dope, fake dope, you were going to get fired. And so that meant you needed to have that evidence and try to make sure you evaluated it carefully. But to answer your question, the realization of the things I did not know when I left and became a defense lawyer was sudden and shocking in such a way as to knock the wind out of me, right? It just emotionally, about the things I did not know that were, the defense was having to contend with. And I cannot think of a time, certainly I'm going to litigate a case, right? And I know you're civil litigators and there's kind of a back and forth discovery. I'm going to do everything I can to litigate a case to make sure I'm getting information. It's not about not revealing information. It's about getting information. And, John Raley really highlights this point. For 7 years, with enormous resources available to him, pounded on the state of Texas with just a do not quit, I'll take you to federal court if I have to, attitude to try to get information, in large part, information they did not know what it was because it hadn't been concealed. And so one of these issues here in the timeline gives me great pause, because you're asking me as a defense attorney to guess what I don't know and ask for it at least 20 days prior to trial. And so you're going to have to bring that home to answer your question. It's not about a complainant. And I had a case just in the last few days that really addresses that point that you're making. That if you'll bear with me, I'll tell you about it. Sure. I don't know what I don't know to ask for it 20 days ahead of trial. All I can do is hope that the state is complying and giving me everything that they should. And this, even the more, what some of the prosecutors have alluded to is the innocuous sections of the bill eviscerate the judge's ability to make discretionary decisions about how to use it. Judges don't like to cut off a victim's day in court. The judges in Texas are elected, and they're going to have to answer for those questions, and they get to employ the discretion about what to do with the evidence already. The bill here before us doesn't add to that. In fact, it restricts it, and it hampers their ability to make these kinds of calls. A case that I just wrapped up, ended up getting dismissed. It was, you think about how can you defend these people is a question I sometimes get at PTO meetings. I have 3 kids, right? And, indecency with child by contact, that's pretty awful. Nobody's in support of that. And the prosecutor's giving information as it becomes available. I don't know until, maybe in this case, 48 hours before trial, that there are some therapy records that prosecutor didn't know about that he got. Turns them over to me, which suddenly, within 24 hours, he turns it over to me. So that's 24 hours before I'm supposed to pick a jury on a guy that could lose his entire reputation, his family and everything else on this thing. And buried in those records, that this prosecutor then complies on sort of an extra agency bit of records, turns this over, and I think, lo and behold, I have responsive evidence with metadata in it that kills this. I know this is a lie. This is done, which I elected in that case to share. And it's over. Because I had a prosecutor who was ethical, but I will tell you, I have to evaluate, and it's not about gamesmanship. It's about...
Well, let me stop you there.
Yeah.
So let's say that you didn't get that piece
Right.
of evidence. Let's say you got it from a third party, not from the prosecutor.
Right.
And so, and obviously as legislators, we not only represent someone like Michael Morton, but we also represent the victim of a crime as well.
Right.
That's why I look at it anyway. And so how would I explain to someone that if it through no fault of the state, like let's say in the exact scenario you described, except for that piece of evidence came from a third party, and the state truly didn't know about this piece of evidence, and then this victim's case gets thrown out because the defense attorney doing your job waited until after the trial started, jeopardy attached, whatever, however whatever you want to call it, and then you raise the issue, the judge throws out the case, or throws out the evidence, which results in the case being thrown out. So I guess what I'm saying is, in that scenario, I don't need you to tell me what to tell the victim, but I'm saying, do you feel like that there should be some type of protection in place for the victim?
There already is, and that is the discretion that is available under 3914 and Heath and Watkins. It's already built in.
Okay. So do you feel like, like you said, you decided to come forward, and say, here's the evidence. What if someone doesn't? If they just lie behind the law, so to speak, and do you feel like there should be any type of protection there for the victim in that scenario?
Well, and the quote-unquote victim in that scenario was patently lying, is the issue. So isn't a victim at all, it
Well,
turns
I
out.
mean, maybe in that scenario. But what I'm describing to you is, I'm talking about, let's say someone gets raped. I mean, clearly that's a victim that had nothing to do with a piece of evidence that you obtained through someone other than the state, the quote unquote the state. Just curious, do you think there's any obligation from the state's perspective to bring that forward at any point in time?
I think that it's already there, right? Like, the solution to that problem is already there, and the state can argue exactly, and you could be the judge. You're making the calculus in your mind right now and in our discussions that the judge has to make in order to determine what to do with that. You can be in the middle of trial and have something disclosed, and the other side can say, I want to have a continuance now. And the judge gets to evaluate whether or not that makes sense. That already exists. There doesn't need to be a change in the law to make that happen.
You feel like that the judge has the discretion, is what you're saying, as far as if it's raised and the issue of suppression is brought up. You're saying just because of the judge has the discretion whether or not to grant the suppression or not. Correct.
And the judge can say, go home, come back next week, after y'all have all had a chance to evaluate this. Jurors go home, everybody goes home.
Yeah, and I think a continuance is a good remedy. I mean, I think that's was something that kind of got discussed at the beginning of today. But I think that a good remedy in this situation, because obviously I want to protect Michael Morton, the person that's in those shoes, but also want to make sure a victim has rights as well. And this committee has has heard testimony before today, that really has focused on victims' rights as well. And so that's why I'm just trying to strike a balance there. And I think a continuance is a much better remedy than suppression in most instances. Obviously, in bad faith, slam the gavel down on the prosecutor if there's bad faith. But if there's no bad faith, I really think a continuance is a really good remedy. And I just we'll leave it at that.
And I appreciate your thoughts. And the issue is that the judge already has that discretion, and then you have a case like Mr. McKinney's where for 4 years the state just doesn't produce whatever it is they're supposed to produce. At some point, the judge has to make an evaluation about whether or not judicial economy and the victim's rights and every other part of that equation dictates another continuance, or is it time to move on?
Well, I'm glad, since you drove all this way, I'm glad you got to testify for more than 2 minutes, and we had a good conversation, so I appreciate your...
Sure, thank you guys. Oh, sorry.
Ms. Jones has a question.
Thank you for coming, Nicole. We've known each other for a long time. And for people who don't know this, correct me if I'm wrong, a lot of part of your practice is you represent police officers who've been charged with stuff, right?
That is true. I did a stint at the Harris County DA's office in our Civil Rights Division, prosecuting law enforcement and public officials. And then later, when I went into private practice, ended up representing quite a few individuals in those roles on the defense side.
Right. So what I can say I know about you is you prosecuted people you thought were bad guys, and were a very good prosecutor. And you defend people as a defense lawyer that some people, I will tell you, like, wonder if you should defend them, like cops accused of doing bad things to people, but you fight diligently for them. And I think you've testified with OP and Q that you think that those substantially change the Michael Morton Act.
I do, yes.
And I think I heard you say that the Michael Morton Act already gives a remedy for a judge to grant a continuance if a judge believes a continuance is the appropriate remedy.
100% in combination with the state case law.
And you also just were asked questions about, do you think the victim, their rights should be protected. And tell me if you believe I'm accurate. If I'm not, tell me where I'm wrong.
Okay.
As a defense lawyer, I mean, this system is supposed to work whether state prosecutes for the victim or for society and for the victim, right? They're the complaining witness in the case. Would you agree?
I would agree. I would agree. I would tell you, and this is not going to be a popular comment, but there's a case called Poe v. Collier. Ted Poe was a judge back in Harris County.
I know Poe.
Yeah, I know you do, but the others may not. Very conservative, and had been a former prosecutor judge.
And in Congress.
And Congress as well. And litigated the issue as to whether or not the state had the right to a fair trial. And the answer to that question under current state law, since Collier versus Poe, is no. The trial is about the accused. That is who carries the constitutional rights.
And so that actually was what I was going to ask. Who knew you were going to jump to the end?
Sorry.
Right. But what I'll say is this. If evidence ends up being suppressed because the state didn't do what they were supposed to do, whether they intentionally didn't do it or whether they accidentally didn't do it, the tie always goes to the accused.
Correct.
And so would you say to a victim where a case got thrown out that you need to talk to the state, they should have done their job?
100%. And on top of that, as a prosecutor, I would have been so mad at a law enforcement agency who kept something buried in their file, like the Alfred Brown case, and didn't turn it over to the person in court until after a person gets convicted. It's unthinkable.
And to the point of a continuance, although I think a continuance may be a remedy, to the accused, like they're literally becoming victims of the system. Like, right? The only victim is not always the victim of a crime. Sometimes the victim is a victim like Michael Morton or all these other wrongfully convicted people, or people that have to stay in jail from this time until the continuance. And I think that as a criminal defense lawyer, it is my job, it is my fiduciary duty to know the rules, to hold the state accountable, to follow the rules, to follow the Constitution, and the system will work.
And tell those police officers, turn that evidence over or you're not going to get to use it.
Thank you.
Thank you for being here. We appreciate it.
Thank you.
Chair calls Amanda Marzullo. And we apologize for the late hour. Your affirmation shows you're Amanda Marzullo on behalf of Austin Community Law Center and yourself, and you're testifying against the bill, correct?
Yes, thank you. And I think everybody who came before me did a great job of fleshing out a lot of the issues with the bill. I just wanted, as a defense attorney who recently expanded her practice to civil cases, I wanted to point out that in subsection A1, just how much of a difference that change makes where they're striking material to any matter involved in. That language that's currently in the statute is based off of an old version of the Federal Rules of Civil Procedure. It's basically a variation of Rule 192. What's discoverable? It's kind of a variation of that. And instead, it's replacing it with one part of the test for admissible evidence. So it's narrowing the scope of discovery from what could lead to evidence to what is evidence. And so that could be a really dramatic change in this case. And also with subsection 2, I can't think of a case that I've worked on over the past 16 years where I didn't submit a broad request for discovery at the outset. And that goes from misdemeanors to capital felonies. And like as other witnesses have pointed out, we don't know what we don't know as defense lawyers. So there is no way that I'm going to be able to make a demonstration to the court that the information I'm seeking is necessary. So those are just the two things that I wanted to point out.
Thank you, Ms. Marzullo. Any questions, members? Okay, thank you for waiting and for being here.
No problem.
The chair calls Jennifer Tharp. Ms. Tharp, glad to have you, and sorry you Drew the black bean of being so late in the
Oh,
in the
no problem,
testimony.
no problem.
You're listed on your affirmation as Jennifer Tharp, Comal County District Attorney, testifying in that capacity and for yourself. And you are for the bill, correct?
Yes, sir.
Okay, thank you.
Thank you. My name is Jennifer Tharp. I believe I've testified in front of many of you multiple times. I'm here in support of HB 3330. But I'd be remiss to say that there have been multiple things that have been testified to that have made me pause and try to look through this bill through the lens from not just a prosecutor. I don't have the experience or privilege of having served as a defense attorney before being a prosecutor. I only know that role of being a prosecutor. There are multiple things that have been said tonight that I thought were interesting, and I'm happy to answer any questions, but I think when you come down to this particular bill, I do believe OP and Q are the most important aspect of it. I was not a part of the group of prosecutors who originally drafted the language in this. My focus this session will be a bill that'll be discussed later this week. However, what I found so interesting is some of the testimony that has been said by both prosecutors and defense attorneys about the world of discovery pre-Morton. So I was a prosecutor when Morton was happening. I was not in the room. I was a hot 2 years on the job as an elected and in probably way over my head. However, I do remember asking some of the other prosecutors, like, well, why is this exactly necessary? Not in response to Morton, but in response to the big picture of discovery. I came from a county where we had an open file discovery policy. And so I was just honestly taken back to hear that defense attorneys, when they were on a case, weren't getting the entire offense report, the 911 call, the videos, the photos, everything. And so I remember thinking back to Michael Morton Act. I'll try to wrap up, I apologize. Just being shocked because it was truly, in my opinion, a codification of making sure that best practices of discovery was put into statute. I think where we are here today is a need for best practices in terms of when new evidence comes forward, how to handle it. Representative Moody, I loved your questions earlier in terms of how you balance the defendant's rights, because sure, there is an impact to a defendant, and I am not going to sit here and say that that's not an impact. At the same time, I would love to sit down at a table with some defense attorneys to talk through Q, to talk about, is there an avenue where there could be more appropriate language? I get the aspect that if a prosecutor had no idea, but that's not just the whole story. Because I will tell you, there are some judges where you have a prosecutor assigned to that court, and that judge and prosecutor become very comfortable with each other. And this could be flipped on the other side. You could have a judge that says, you know what, I work with this prosecutor all the time. They're a great prosecutor. They had no idea about this. But then you go to that second prong where it really does have an impact for a defendant. And if it really does have an impact for a defendant, that evidence should be suppressed, in my opinion. And so I would welcome any opportunity to sit down. I will tell you, before this hearing, I actually sat down with Lindsay and with Alec from your office. I respect their perspective as being a defense attorney and looking at it from the prosecutor role, because that's how good law is made, is when both sides are at the table and they're truly trying to sit down and drill down what the issue is, not just looking at one extreme case or another bad situation, but let's drill down and look at it from a Texas perspective.
Any questions, members? Okay, thank you. Oh,
No, just a comment, not a question. No, I appreciate exactly what you said, is the opportunity to sit down. Because part of what I was kind of running around in my head is I remember as we did this over 10 years ago, right? You have stakeholder meetings, you sit down and you talk through things, because there's a give and a take, right, when you're doing these things. So I appreciate your willingness to sit down, because I think if we're going to do something, then sitting down with the Innocence Project and their experience, sitting down with TCDLA and their experience, sitting down with Mr. Morton himself. And while that is an example that, you know, is pretty egregious, I think because of what he went through, I think he has a right to be part of those conversations as well. And so, and his counsel. And so I applaud you for wanting to do that, because you've always done the right thing in these conversations. It's a balancing act. We want to get it right. To Chairman Cook's point, there are people on the receiving end of this that didn't ask to be part of the criminal justice system either. And so you got to balance those things. So I appreciate your willingness to do that, because I've always been a big believer if we sit down and we work through this, we can get to a place that works. And so thank you.
Ms. Bowers, you have a question?
No, just a comment. Thank you so much. I couldn't have said it better myself. Just the working together and bringing all those voices to the table, along with their ears so that we're hearing each other. So thank you for really not just talking the talk, but walking the walk.
Ms. Jones?
I too am willing to sit down with you. I mean, I actually don't think I have to drive all the way to Comal County, which I've
No,
been
I feel like I'm here more.
because you're here a lot, so you're welcome to come to my office.
Absolutely.
All right,
I
thanks.
would love that.
Thanks. Any other questions, comments? Okay, thank you for being here, Ms. Tharp. We appreciate it. Is there anyone else here to testify for, against, or on House Bill 3030? If not, the chair recognizes Representative Cook to close.
Chairman, if you don't mind, I would close here.
Sure.
Yeah, so I mean, obviously, there's been lots of discussions, and I agree with DA Tharp, her comments at the end. I certainly welcome the opportunity to work with anyone that was here today or otherwise. I do think that we need to strike a good balance here and make sure that the protections that have been established by the legislature back in 2013, that those are safeguarded, but I do want to make sure that we balance those for the protection of victims, and so that cases are not unnecessarily thrown out or evidence suppressed that results in a case being thrown out. I just think there has to be a good balance there, and I just appreciate the committee's time today. I know it's taken several hours, but it's a very important issue. I know a lot more work was done when the Michael Morton Act was passed, and justifiably so. It was a wrong that must have needed to be corrected, and I want to applaud the prior legislature in getting it done, and I would like to have an opportunity to work with anyone that's willing to work together on making changes to HB 3330 to move it forward, and I would be glad to answer any questions if there are any.
Any questions, members, from Mr. Cook?
Otherwise, I close.
So Mr. Cook closes. If there is no objection, the chair will leave House Bill 3030 pending.